Milord, one request.
Yes.
One NHI matter, my lord.
One.
In a NHI matter, arrest warrant has been issued to the project director. There is some urgency.
Tomorrow.
Tomorrow.
Just take all the memos, call the list.
My lord, serial number 77, my lord. Last hearing, when I requested to take this matter on top of the list, now it's a serial number 77. It may not reach, my lord. It may take a little early.
See, we will see. Yes.
One request for
Number one?
adjournment.
Huh?
Serial number 71.
No, he'll call. Adjournments you want.
Yes.
He'll call page.
Milord, my
Judgments.
one memo for posting, Milord. Attachment warrant has been issued against the Jilla Panchayat.
Petition file.
Milord, today, Milord.
All fresh matters, if you give to the court officer, it will come
Milord,
tomorrow.
urgency is that, Milord, warrant has been issued to the Jilla Panchayat.
Come, all fresh matters, there is a direction to post next day. Give it to the court officer, don't have to mention.
Kindly tomorrow, Milord.
Tomorrow.
It will come.
Tomorrow, sir.
Yes, next.
Page wise adjournments. Page number 1, serial number 1 to 3. Page number 2, serial number 4 to 10. Page number 3, serial number 11 to 19. Page number 4, serial number 20 to 28. Page number 5, serial number 29 to 30.
Not required. From preliminary hearing again, B group, all from B group. Your matter is?
B group 71, Milord.
70.
Yes.
I have made a request to the other side as well. 11th or 12th, if it is convenient to my lord.
2015 matter, my lord.
This is matter on 17th February.
11th, my lord. Some emergencies. Interim order may kindly.
Interim order earlier granted is extended.
No, serial number 80,
80?
86.
86.
No, sir, I requested next Monday or Tuesday.
No, yes, to call the next page.
Sorry, Moods.
Yes.
Serial number 84.
Page number 12. Serial number 68 to 66.
77
76.
to 80.
Page number 13, serial number 77 to 80. Page number 14, serial number 81 to 86.
No,
Serial number
86.
84, Muladi.
Hmm.
The records are necessary, Muladi. Candidate next week candidate.
Ravindra Armani. Geeta KM. 84. Ravindra Armani.
83, sorry, 83. Muladi.
80?
83.
Chem Darigon.
83.
Preeti Shashank.
Call for the records. This is there to call for the TCR.
Interim
This
order.
matter. What?
Apportionment of Muladi compensation, Muladi. Apportionment of compensation.
You know, interim order must have been granted for
Earlier granted till today, Muladi.
interim order earlier granted is extended until further orders.
Please.
Call for the records. Yes. Hmm?
Further hearing.
Why is it in further hearing?
Other side not come, Muladi, in last occasion, Muladi. That's
Then
why.
why are you submitting now that?
No, I am not Muladi further. Only B group, in B group, and that temperature.
No, no.
Ready, Muladi, ready.
Then
Please,
you shouldn't have
please,
made that
please,
mention
please.
when it is listed for further hearing.
Please.
Let it be there in the list. Yes.
No, serial number 86, parted matter. I request next Monday, my lords. 86 parted, next Monday in the parted only.
This is matter on 19th of February.
Interim order may be extended.
Interim order earlier granted is extended. Please call the list.
Number 1. Dismissal serial number 1. Ashok S. Menshinkai.
For the petitioner, Muladi.
Yes.
The Ashok Menshinkai is no more, Muladi. Ashok Menshinkai is no more, Muladi.
He is no more.
No more.
Chem Darigon.
I filed application for recalling Muladi. Dismissed for non-prosecution in the year 2013.
Hmm.
Muladi, the writ petition filed against him, Muladi, order passed by the execution court for deliver of warrant, Muladi.
So when did
Muladi, the RSA is pending before this honorable court.
you know? When
Please.
did you file wakalat?
Muladi, I filed wakalat, Muladi, 9/1/2026. Recently, Muladi, 9/1/2026.
9/1?
2026.
When he died?
In the year 2021.
And then what is happening from 2013 to 21?
Muladi, the parties, my lord, the not aware of that.
That kind of.
Allah,
the
one more
courts-
thing, my lord, the RSA is pending. That is also dismissed for
pending, let it be
non-prosecution.
pending. We can't entertain these kind of writ
Now, my
petition.
lord, the execution court,
Petition of 2010.
Please.
Order, it was dismissed for default in 2013.
13, my lord.
Advocate was very much there till 2021.
Please.
What the client was thinking that what is happening to his case from 2010 to 2026 till you are on record?
My lord, the now, my lord, parties, my lord, in the execution court, now issued warrant to the, my lord, the petitioner. And that impression, my lord, the
No, you please tell the court on these ground, can the delay of how many years?
13 years.
13
13 years,
can be
13 years.
condoned? It can't be condoned. Please come. I number 1 of 2026 is filed. Seeking to recall the order dated
23/10/2013.
23/10/2013. Where is that IA? That's filed for now. It is stated that the writ petition was dismissed for default for non-prosecution on 23/10/2023. The
2013,
The
madam.
petitioner was represented by the counsel, Sri Ashok is Nasinkai. The petitioners have recently learned that their counsel passed away. Due to his untimely death, there was no representation on the date the matter was called for hearing in 2013, nor was there any communication to the petitioners regarding the status of the case. Petitioners are residents of a rural area and are agriculturists. They were under the bona fide impression that the matter was pending and they would be informed by their counsel if any action was required. Being unaware of the death of their advocate, they could not appoint a new counsel. Hence, delay of
13 years, my lord.
13 years occurred. This court has perused the reasons that are stated and also the submissions made by the council in tune with the same. It is submitted on a query from this court, when the council appearing for the petitioner, earlier council died, it is stated that it was in the year 2021. If that is the case, the reasons that are stated for condonation of the delay cannot be considered. And this is not, and the court cannot consider delay of 13 years without there being a reasonable explanation for the delay. Accordingly, I number so and so filed for recalling of the order passed in 2013 is dismissed. Next.
Preliminary hearing matter, serial number 2, Rajshekhar Burji, 1B Dodatti, Ganga.
2 to 4.
So number
Yes.
5, Lords.
That blinds, AC blinds, no? Straight away coming on to my face. Yes,
Lord, petitioner's father, my lord, was owner of, my lord, the survey number 256 measuring 3 acres 16 gunta.
who moved the memo?
But I have moved the memo.
What is urgency?
My lord, now, my lord, there is a direction by the KIDB, my lord, to consider the case of the petitioners for appointment, my lord, in the fifth respondent company, my lord. The petitioners have the petitioner's property in addition with others' property, my lord, to an extent of 600 acres, my lord, was acquired by the KIDB and was allotted to the respondent number 5, Tata Motors, my lord. Now, my lord, under the lease cum agreement, my lord, and under the agreement, my lord, there is a clause that, my lord, the beneficiaries, the landlords must be given an opportunity in the company, my lord, and they should provide an appointment, my lord, depending upon their educational qualification. Now, my lord, the KIDB, my lord, has directed, my lord, that the company, my lord, to accommodate the petitioner.
To get that.
Yes, my lord. But I have extracted, my lord, the lease cum agreement, my lord, is also there, my lord. Relevant portion, my lord, is at, my lord, ink page 19, my lord, typed copy, 18 and 19 and 20, my lord. Item number starts from 13, 14 and 15, my lord. I have extracted in my writ petition also, my lord. Not you shall, item number 13, you shall create maximum possible additional employment opportunity and provide minimum 80% of employment to the local people on overall basis. However, you shall employ 100% of the local people in case of group C and D. Item number 15 not is relevant. You shall provide employment to at least one person in each displaced family of the erstwhile land owners in respect of land allotted to you, depending on their qualification and suitability.
Appears for this beneficiary.
Lords, I have affairs, Lords.
What are your instructions?
Lords, you will get instruction, but next week, Lords, any date may be fixed, Lords, you will get
Now
instruction.
he says that there is a,
Please.
then you
Please.
have to, when are you going to implement that?
Oh, like
Where
it
is that letter? You're saying that now there is a direction to them to.
Yes, no, that is, my learned friend appears for KIDB, there, annexure C, D, my lord. Annexure C, ink page 24, 20.
This is addressed by which respondent to which respondent?
My lord, annexure D is addressed to respond number 5, my lord. Ink page
Respondent
24, my
number
lord. Annexure C1,
5 to
ink page
Tata
24.
Motors.
Yes.
Now,
Now, my lord, there is a direction saying that, my lord, since the land is acquired and under the lease agreement, my lord, there is a clause to that extent also, my lord.
according to you.
Yes.
Respondent has issued a letter to the fifth respondent.
Yes, my lord.
When was this letter?
No, this was in the year 2022, my lord.
No, but 2000?
22, 19/12/2022, my lord.
Then what are you doing from 22 to
Lord,
now?
I have been, my lord, the next letter, my lord, is 21/1/2023. Every now and then, my lord, I have been approaching the KIDB and the respondents, my lord.
No, you are comfortable right from 2022.
I'm sorry, my lord,
not even
the-
up
since-
to the court, and now you suddenly feel that.
No, my lord, the latest, my lord, I was unable to get the lease the
Instructions.
Please.
The counts for the respondent. Which respondent you appear? Third respondent.
Fifth respondent.
Fifth respondent shall get necessary instructions in the light of the letter addressed by the third respondent to the fifth respondent. This is smart after 2 weeks.
Please.
Yes,
Seal number 3. Mohammed Irshad MH.
yes.
Lordship, I am appearing for the petitioner, Lordship. This is a matter for defreezing, Your Lordship. The prayer was mentioned in the prayer is just to mark the lien, rest of the amount will be defrozen, Your Lordship.
Direction to the IDFC bank to mark the disputed amount under lien and immediately defreeze the remaining balance in the petitioner's account. Yes, this is a matter where on the last occasion this was heard.
Yes,
And,
that is different matter.
That is a different matter. What is this? Why this direction?
My lord, appearing for the respondent number 1, my lord, bank, my lord.
Lordship, in fact, it is a private bank.
My lord, we mark the lien, my lord, as per the instruction of the state, my lord. Their account has been freezed, my lord, only on the instruction of the state, my lord.
Where is that representation? Where is that communication?
My lord, as per annexure, my lord.
Huh?
As per annexure, my lord, there is a page number 16, my lord.
15.
16. The endorsement which is given by the respondent, first respondent, that my lord, these are the transactions which are to be liened.
No, where do you get it? Where is the endorsement by this respondent directing to freeze your account?
Lordship, I may make one submission, Your Lordship. There is a two type of freezing, Your Lordship, debit freeze and lien freeze. The Honorable Coordinate Bench, Principal Bench is dealing with the same conditions of matter. Where right to.
First of all, you have to tell the court what are the facts. After the facts, then the connected matter or similar matter will come. You are saying that there is a direction. Where is that? That I want to see.
Lordship, I may make one submission, Lordship. Lordship, what is the matter is the right to information which should be conveyed by the respondent number 1. Is it not been conveyed until now? Because of us, we approached the bank. This lien has been happened in 2023, Your Lordship. And we approached the bank, we got only one acknowledgement till now. The debit freeze has been done, Your Lordship. Hence, there is a government.
I make a submission. For my lords, this writ petition is not maintainable because the prayer is against the private party, against the bank.
Anything is maintainable. That's how the petitions are entertained.
And so kindly,
Beyond the jurisdiction, beyond the powers conferred with the court, anything is, what is this direction? It is not, it doesn't even, and not even under the Surface Act.
and even they did not contact, my lords, the communicate to the my lords.
Not even one document. And on the top of it, he says that the principal bench has granted order.
Lordship, I may submit the judgment passed by the coordinate bench.
I will not do unless and until you tell me the facts. You
So,
convince
Lordship,
the
the
court.
fact is, there is a cyber portal 1930. If anyone have the aggravated on that situation, they can call the cyber portal. Immediately lien will happen, your lordship. There will be no consultation. The victim means one who has the bank, one who operates the bank, he will not receive any information from the bank side, nor by the police, nor by the state, nor by the any lordship. And we made the respondent number 2, 3, your lordship. There is a multiple FIR, multiple complaint registered against the petitioner's account in several states, your lordship. Now we are approaching before this.
What you're supposed to do is, in connection with any crime, if your bank account is seized, the remedy available to the petitioner is to approach the court before whom or wherever the crime to the jurisdictional court and file an application for this. Why should the High Court do it?
Lordship, I may make one submission, lordship. When we approach the bank, your lordship, because we are the customers of the bank. When we approach the bank, we will not get any information that why our bank has been frozen. Until and unless, your lordship, if we get an information where it has been happened, how it has been happened, lordship, for indefinite.
Come to your prayer. What is that you asked? Please come to your prayer. What is the prayer? Let us see.
Issue a writ of mandamus or any other appropriate writ order to direction of IDFC First Bank to mark a disputed amount 27,645, your lordship. Lordship, according to the annexure A, which has been given by the bank, respondent number 1, my disputed amount is only 27,645, your lordship.
Where do you get that? Where do you get that?
Annexure A, your lordship. This has been given by the bank. In that, your lordship, there is a transaction. Amounts 6,897, 8,006. This is what they have given by the bank. Only single paper has been given by the bank. When we calculate that amount, it amounts to 27,000 and plus, your lordship.
Who appears for the bank?
Who appearing to the bank, my lord?
Yes.
My lord, as per the instruction of the my lord state, my lord, we are freeze the bank account, my lord. My lord, they are given the reason.
What is the instruction of the state?
State, my lord, they are involved in the financial cases, crimes, my lord. As per the basis of them, that represent the letter of the police station, my lord, we are mark the lien amount, my lord. And as per their instruction, my lord, bank account has been freezed, my lord.
What are the crimes registered?
Crimes, my lord, I will place, my lord, I take instruction, my lord, regarding that, my lord. I will place all the documents, my lord.
The respondent bank shall place before the court what are the crime numbers regarding in respect of which the petitioner's bank account is seized. This is matter next week.
Lordship, date may be given, your lordship. Lordship, one submission which I have to bring before this honorable court, lordship. According to the BNS section 101, it clearly states, your lordship, I may forget that section. If one property is seized by the state, they are entitled to give the instruction, means they entitled to present that seizure before the magistrate, your lordship. From 2023, I didn't get any intimation. I didn't get any notice. When I approached the bank, they given only one acknowledgement stating that this is the dispute amount, your lordship. And even though the coordinate bench also state clearly, only the bank have to mark the lien. Bank have to mark only lien.
Number 4.
The same order.
You don't place any paper before the court, and the court have to understand all these things without any paper. Without
Lordship-
any, have you given any representation to the bank seeking, I want these details?
Lordship, if we
Did you
approach
ask the
the
bank?
Lord, even my lord, they are not approached the bank, my lord.
Lordship, we approach the bank, your lordship, they are not
Yes.
entertaining
Then
us. And
show
second
a
thing,
piece of paper, Mr. Council, that you have approached the bank. Show a piece of paper.
Lordship, that's what they give in the acknowledgement. That's what annexure A, your lordship.
No, that you are not convinced, that you are not convinced. Then what you should have asked, you should have addressed a letter to the bank, a legal notice to the bank, saying that in respect of what is the letter of the state, in which case, what are the crime numbers, why my account is freezed, is what are the minimum requirement we should find before filing the petition.
Lordship, that's what the, we are.
Even my lord,
Lordship,
as per same, my lord, annexure
Lordship,
A, my lord.
Lordship,
Which is
one
letter
submission.
and issued, my lord, in the rep
Lordship,
2024, my lord.
Lordship,
Their
one
further
submission
inspection, my
which
lord,
has
in the
been
rep
raised now.
2025, my lord. Now, my lord, they have come up with the allegation against the bank, my lord, which is not
Lordship, one
sustainable under the law.
submission, Lordship, on the
If
same
any
issue,
one person is not
on the
kept for
same issue, coordinate bench has been dealing with the same issue
Mute your first.
where the right to information has been arrived. The canvas of right to information which should be given by the bank, which
Yes.
has been.
Seal number 5.
Your lordships,
Yes.
I appear for the petitioner, your lordships. In this matter, IA 15 is filed by the sole plaintiff in the partition suit, seeking the liberty to withdraw the suit and file a fresh suit, your lordships. This is nothing but allowing the indirect amendment of the suit. If there was some formal defect which the suit is going to be dismissed, that could have been understandable. But here they say only the property is being undervalued and he makes an application and withdraws the suit. And the liberty is being, even if he is withdrawing the suit, we don't have any objection. But the liberty is being given to the defendant, sole defendant. My specific contention is I have done the partition.
Please come
We
to
have
the impugned order.
Your
Come to
lordship,
the
the
impugned
impugned
order.
order is on page 53. IA 15 filed by plaintiff under order 22 rule 3. 1 subclause 3 is hereby allowed, your lordships. And the IA, your lordship may kindly turn to the application filed by the petitioners, plaintiff,
Yes.
Respondent herein. He says that the suit properties are being undervalued and he wants to make and pay the proper court fee. That could have been done without even withdrawing the suit. Now this is a ground being given and opportunity being given to amend the suit and giving inordinate.
Council preparing for the petitioner submits that when the plaintiff has filed an application in the suit of 2018 under order 23 rule 13, review section 151 C2, seeking permission to withdraw the suit with the liberty to file a fresh suit stating that he wants to. There is formal defect in the suit and for that reason they want to withdraw the suit. It is submitted that if the plaintiff wants to withdraw the suit, the defendant has no objection. But in this case, the court had given the liberty to the plaintiff to file a fresh suit. It is submitted that the same could have been rectified in the very same suit and the suit is of the year 2018. Considering the submission of the land counsel for the petitioner, there shall be stay of all further proceedings. The petitioner shall take out hand summons and file on the council appearing for the respondent and shall file a memo to that effect by 18th of February or else the stay granted by this court stands vacated. In addition to that, the registry shall issue notice. Yes, 6.
Much obliged.
Number 6. Sajid Ahmad Budwal.
Yes.
Number 6.
For petitioner, my lords. My lords, the petitioner are the active members of the Lions Club Ranebinur.
Andra,
My lords, the petitioner made. Lord, the petitioner made a application to the respond number 3 that the petitioner are the active members of the Lions Club and to accept their membership for the Mahatma Gandhi Educational Society. My lords, the respond number 3 issued a reply stating that they have not paid the membership fee of rupees 100. My lords. But on 26/3/2025 itself, my lords, they have paid rupees 100 and At page 45 may kindly be seen, my lords. The bylaws of the respond number 3.
Where is this endorsement dated 12/9/2025?
At page 65, my lords. My lord, it is in Kannada language.
What it says? Take
My lord,
that.
side. At page 16, my lords.
16.
Please.
Yes.
Lord, at last para, my lords, page 21.
Yes.
Based on the above observation, you have not provided information to the
Sort
society.
of above observations, let us
My lords, that they are not the members of the Lions Club.
Since the registration of the society,
Please,
read that at page 20.
20.
Yes.
Since the registration of the society, there have been only 11 members and the same 11 committee members, and no additional membership has been acquired until now. Those who desired membership deposited the fee at Canara Bank on the date 27/3/25. However, the audit report of the said society dated 31/3/25 does not reflect this deposit. Upon examining the documents attached with the complaint application, information regarding the payment of the said amount was provided to the society on the date 28/6/25, making it difficult to determine whether the membership fee was paid within the stipulated time. The society's bylaws allows the payment of membership, but according to the Karnataka Societies Registration Act, Section 2, Clause B, member means someone who, after obtaining membership in accordance with the rules and regulations of the society, pays their subscription and signs the list or register of its members. Therefore, it is necessary to follow the society's bylaws, number 16 clause H, the Karnataka Societies Act 1960 and the rules 1961, and accordingly action must be taken regarding the granting of membership in compliance with the said act and rules. According to society's bylaws, number 4 clause D, member means an active members of the Lions Club Ranebennur, but no documents have been presented in this regard. According to society's bylaws, number 14.
Let's look at the bylaws. What do the bylaws say?
My lords, at page 45, my lords. Para number 9, clause A.
What is your case that you are already a member?
Please, my lords. My lords, may kindly see in the translated copy, my lords, which I have produced. My lords, may kindly see page.
No. What is your case? You are a member of the.
Please, I am the member of the Lions Club. Now they are not accepting our membership for the Mahatma Gandhi Educational Society, Ranebennur, my lords. That is my prayer, my lords. Second
Who is
prayer.
not accepting?
Respond number 3, my lords.
Who is respondent number 3? Mahatma Gandhi Educational Society.
Oh, yes, ma'am.
How can you seek a direction to Mahatma Gandhi Educational Society?
Because, my lords, as per the bylaws,
No,
if
no.
I have paid
Is it the duty of the court? Then if they are not doing it as per the act, what is the remedy available? Let us look at the act.
Please.
Yes.
But as per their bylaws itself, my lords,
Yes, if they are not following the bylaws, what is the remedy available to them? Even for that, a writ petition will be filed against a private society. I can understand you are questioning the action or inaction of the second respondent,
please.
who is a district registrar of societies. You say that third respondent is not doing it, so I am come to the court. What is the remedy under the framework? Remedy is not writ petition.
Please.
You please avail the remedy available to you. The present writ petition is filed, seeing the following prayer. Third respondent is a private society, that is Mahatma Gandhi Educational Society. The grievance of the petitioner is that but the order impugned The third respondent has issued an endorsement stating that the petitioners have not provided information to the society regarding the payment of the membership fee within the stipulated time. Furthermore, the application or form seeking membership or other documents have not been provided in accordance with the Societies Act. Also, no documents have been provided regarding being an active member of the Lions Club Rane Benur. Therefore, at this stage, it is not possible to consider the petitioner as a member of the society. After becoming a member, you can review and obtain the society's account at the society's level. If the petitioner feels any injustice has been done, he can file a case with the competent authority and seek redress, and the applications are concluded at this stage. Questioning this, the present writ petition is filed. This court is not able to understand how a writ petition can be, how a mandamus can be sought against the third respondent. When the order itself says that to the competent authority, they can file a, they can seek their redressal. The petitioner has come before this court, filing this writ petition. The writ petition, the relief as sought against the third respondent, which is a private society, educational society, is not maintainable before this court. If the petitioner is agreed by any of the action of the third respondent and any remedy is provided to the petitioner, he is at liberty to avail the same. Accordingly, this court is passed the following order. The petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy under law.
Please.
Seal number 7.
Yes.
I'm for the petitioner in this case. my lord.
AGA.
Yes.
Yes, my lord, I have challenged the acceptance of the new body by the second respondent, my lord, for the petitioner society, my lord. My lord, the new respond number 3 to 9,
Who has accepted?
the respond number 2 registrar have accepted, my lord. My lord, since my lord, they have not dissolved the existing body, my lord, without dissolution of the existing body,
That's the impugned order of approval of the executive committee dated 14/3. Passed by respondent number 2. Who are you?
I am existing members, my
When
lord.
were you, when your body was appointed?
My lord, in the year 23-24, my lord.
23-24. What is the duration?
3 years duration, my lord. My term is expires on 23-24, my lord.
Your term?
Is expires on 24-25, my lord. That time they have formed,
No. What is the duration of your?
my last 3 years is the duration.
So if you are appointed in the year 23, 3 years duration is to 26.
Please, my lord. My lord, without dissolving the existing committee, my lord, new committee having been formed, my lord, there is no general,
When was the new committee formed?
my lord, on 21-2025, they have proposed for the new committee, my lord, and 21 January 2025, my lord. There was a proposal, my lord.
Your term expired.
My lord, my term, I have appointed for the period of 23-24, my lord.
Then
My lord, new committee is formed, my lord, against to the bylaws, and they are not followed, my lord.
there is a different aspect.
Please, my
First
lord.
petition of yours is that it should be, no, it should be dissolved and other committee has to be formed.
Formed, my lord.
No, your time itself, your tenure itself has
Do-
lapsed. What is the prejudice that is caused to you?
My lord, my term is till 24-25, my lord.
But this is 24?
25, my lord.
25 of which year? Till what date? When you are appointed, when the 3 years term will start and when it will end? There should be a specific date for that.
Lord, may kindly have it on tomorrow, my lord, I will.
Tomorrow it is not possible. This is matter of 2 weeks.
My lord, a date may be, my lord. Yes, my lord.
Matter on 17th of February.
Unless notice has to go to the private respondents.
We have to first understand what is this
Yes.
problem.
Please.
Seal number 8. Santosh R. Polkar.
Yes.
My lord, following the annexure A, my lord, that is a
Yes.
letter dated 8/10/25, wherein my lord, the education loan application
of the petition number 1, my lord, is rejected by the respondent number 2 on the ground that the CIBIL score of the father, that is petitioner number 2, is did not meet the bank's guidelines. My lord, the petitioner number 1 is a merit student and he has secured a.
This relief.
Yes.
We will issue a direction to the bank to issue the loan to you. High Court under 226.
My lord, already there are citations of the Kerala High Court citations are there. Same, on the same ground, Lord. And he's a merit student, my lord.
From now onwards, whenever a bank refuses to give a loan to the borrower, borrower will file a writ petition. Under 226, High Court will direct them to grant the loan.
My lord, that he is a student, my lord. He is a merit student.
Now issue is whether he is a student or whatever he might be. No, you are a borrower. It is a bank.
Yes.
Bank has their own guidelines, whether to grant, not grant. Nobody can compel them.
But those guidelines have not been followed properly, my lord. Because
How
if
can
the
you file a writ petition against that?
no, my lord, it is a future of that petition number 1, my
So
lord.
what? So what?
No,
That
he
is
is a
not
merit
their-
student.
That
No.
is not their, they are not doing any statutory duty that is, you are a customer. It is a bank. They are doing, it is between two people. And the High Court has nothing to do in these kind of matters.
My lord,
If there is no end to this, if in a way now whatever the bank has to do, High Court will decide. Whatever the cooperative society, private society do, that also High Court will decide. First of all, how a writ will lie, how it will under Article 12, how this writ petition is maintainable. It's a business transaction, isn't
But
it?
if the
It is not a
banks-
beneficial, it is not a beneficial thing.
My lord, one submission that if the banks do not follow their guidelines properly,
But
then
that
automatically.
it is not the remedy. If the bank is not following, they have an ombudsman.
My lord,
If you have any complaint, you should go to them.
it will take long time, my lord, because his future is.
Sorry, this is not the manner in which you file the writ petitions and the writ petitions are entertained.
My lord, one date may be given. I will submit that how the writ petition will be maintainable under. I will next date on.
I can understand under the Surface Act, not a mandamus to the bank to grant you loan. No, you will not get any judgment.
No, we have
Even
provided
if you are
a-
getting any judgment, I will not follow it because that is not the law.
My lord, we have provided all the.
Give the judgment. Yes, I'll look at it. Give the judgment.
My lord, one date may be given because.
For what?
I will secure one judgment of honorable court. Next date I will submit.
This is matter on 16th of February. 16th. Yes, next.
Seal number 9. Ms. Salma.
This is parole matter, my lords. My lordship already taken a decision.
On 7/1/2026, there is no representation on behalf of the petitioner.
Not similar matter.
So there is no representation.
And in similar case, my
The
lordship.
present writ petition is filed seeking the following prayer. The petitioner is seeking a relief from this court to direct the respondent number 2, that is the Chief Superintendent Central Prison Dharwad, to release the petitioner on general parole for a period of 90 days. The petitioner has come before this court seeking parole. As per Rule 191 of the Karnataka prison rules, the Inspector General of Prison may release any person on ordinary parole for a period of not exceeding 30 days, which may be extended for such time, not exceeding 30 days at a time, as a Inspector General deems fit. Further, a prisoner who decides to be released on ordinary payroll shall submit an application to the superintendent, who shall forward the same along with his remarks to the Inspector General, along with nominal roll of the prisoner and such other information as may be required. The superintendent shall ascertain from the executive magistrate of the concerned taluk and the police concerned particulars of the sureties before accepting them, and the genuineness or otherwise of the purpose for which the prisoner has applied for grant of parole. And the executive magistrate and the police concerned, within 15 days after the receipt of the such reference, forward their report to the superintendent, failing which it is presumed that they have nothing adverse to it. If no adverse report is received within such time, it shall be presumed that the concerned police and the taluk executive magistrate have nothing adverse to report against the prisoner regarding the request made by the prisoner. The superintendent shall thereafter make his recommendation to the Inspector General of Prisons, who shall examine and pass suitable orders for release of prisoners on parole, subject to the conditions. The petitioner, without availing the remedy that is available as per section 191 of the Karnataka prison rules, as per rule 191 of the Karnataka prison rules, have come before this court. Such a writ petition is not maintainable. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy under rule 191 of the Karnataka prison rules.
Seal number 10. Sunil Kumar.
My lord, I am the petitioner, my lord. In this petition, I have challenged, my lord, the impugned order passed by the respondent number 4, who has adjusted my bills pertaining to vehicles, my lord, for the tune of 5,74,000.
Who is respondent number 4?
Respondent number 4 is the executive engineer, my lord.
What did you do?
He has adjusted my other bills amount towards, my lord. The brief fact of the case is this, my lord.
Who appears for this HESCOM? So and so petition is permitted to take. It shall serve the copy of the petition of the council. The registry is directed to print the name of so and so. This is matter on 10th of February.
10.
Please.
Seal number 11.
7.
Urdhwaj Gachinmat.
Yes.
2 weeks time, my lords. Only grant 2 weeks time, my lords.
This is matter on 11th of February.
Yes.
10th.
Case 12.
Seal number 12. Please.
Appearing for the
Question side.
petitioner, my lord. Here, my lord, my tender was rejected only on the ground that earlier work done certificate was not furnished on the online, not submitted online. But my lord, at page number 32 of the petition, it is clearly shown, my lord, at serial number 567, I have submitted my work done certificate, and along with this read petition also at annexure F series, I have submitted my.
Your instructions.
Today only I have filed the wakalat.
Yes.
My lord, one submission. Then, my lord, let there be an interim order, my lord.
No interim order.
No, my lord,
Instructions
not
by
to-
tomorrow. Yes, let's.
Tomorrow, my lord, please.
Seal number 13. Puliwad Sharnappa.
Please,
Shivappa.
my lord, plaintiff filed a suit for declaration injunction and adverse positions, my lord. I am the dependent number 3 and 4 for impleading applications, my lord. IA number C, my lord, impleading application is there.
Push for declaration. You are a
Declaration.
third party.
My lord, I am the dependent number 3 and 4, my impleading applications, my lord, before trial court, my lord. For purpose of, my lord, I am dependent number 1 is the owner of the property, my lord. I am the earnest money, I have 50 lakhs rupees paid out of the 3,50,000, my lord. I am seeking remaining amount, my lord. They have not denied. Therefore, my lord, I am seeking impleading applications, my lord. But in trial court, consider that you are not dependent number 3 and 4 is not necessary parties and reject that application.
When did you enter into an agreement with them?
My lord, application, my lord, suit is for status is for issues, my lord. Now next.
No, I'm asking. The suit is of which year?
2022, my lord.
2022.
Please, man. I'm filed
According to
application
you-
2020.
According to you, you have entered into an agreement with the defendant.
Please, my lord.
When was that?
My lord, agreement was occurred on, my lord. Please, man. Agree, 5/11/2022, my lord.
5/11/2022.
2022. Suit is filed on 11/10/2022, my lord.
11/10.
My lord.
So you have purchased, you have entered into an agreement after the suit is filed.
Please, ma'am.
Please come to the impugned order now. Come to the impugned order.
Please, please, ma'am. Impugned order.
Yes.
My lord, order IA number 6, my lord. In F, annexure F, my lord. The applications have filed these applications under Order 1, Rule 10, CPC, implead them the dependent number 3 and 4 in this case. The applications supported by the affidavit by one, the applications were as stated that the himself and another applicant have entered into the agreement sale 5/11/2022 with the first dependent, that despite having received the advance amount rupees 50 lakhs out of 3 crores 50 lakhs, the first dependent did not come forward to sell the suit property. In this regard, even the legal notice has been got issued, yet she was not bothered to perform her of the contract. The suit property is the subject matter of the sale agreement, but the plaintiff have not arrayed them to parties to this suit, and though they are necessary parties, if this application has not allowed her
Now you have paid the money to him. You file a suit for
specific form. My lord,
you file it.
specific performance. The trial court is also come to conclusion. We have filed and suit for specific performance, my lord.
Not come to the conclusion. If you're not, you file it. Now,
No, my lord.
plaintiff is seeking declaration.
Declaration,
in respect of a property
adverse portions
against the
the dependent number 1.
How are you a proper and necessary party to that?
My lord, I am
You have
the
entered
and
into an
same very
agreement.
in respect of the same property.
With defendant number so and so,
Please,
subsequent to the filing of the suit.
please, ma'am.
And now, if you are entitled for specific performance, that you get it, that you have to seek.
My lord, I am seeking for specific performance in separately, my lord. But in meantime, I am compromising the dependent number 1 and the plaintiff's is there. I am the infructuous that against our property is our suit is also infructuous, my lord.
What will happen is, even if a suit if he is declared as a owner of the property and
Please, ma'am,
defendant is not the owner,
Please,
then what will follow? You will only get that amount what you have paid to the defendant in your specific performance suit. So how your presence is required in this suit at the time of trial?
Because, my lord, I am the established in this case, my lord. He is also earnest. I am the prima facie purchasers, my lord. The earnest money.
Suit, what will be decided is whether the defendant is the owner of the property or not, isn't it?
My lord, dependent number 1 is the owner of property.
The owner of the property or not?
Please, my lord.
His right to the property will be declared by the court.
Please, ma'am.
If whatever it is,
Please.
what is if you are not a party to the proceedings, what is going to happen?
My lord, if it is not
Ultimately,
property,
your
once,
relief
my
is
lord,
against it.
one is, my lord, the plaintiff and dependent number 1 is the compromise, my lord. Otherwise, my lord, if it is decreed, my lord, the entire property is
Court
gone
will
to the.
decide.
Please.
Court will decide in the suit for declaration about your agreement between both of you, whether there is a valid agreement, whether
Please,
you are
please.
entitled for specific performance.
Please.
It will not be decided. Please.
My lord, if it requires, my lord, is necessary party, it requires, my lord, necessary party
Agreed
is
with
there,
order
my lord.
passed in I number 6, is number 1 to 8 of.
Because of the, my lord, already in my amount is a heavy amount is there, 50 lakhs amount.
Your remedy is elsewhere, not before this court. Before where the suit is pending. OS number 28 of 2022. I number 6, OS number 28 of 2022, dated 29/2025. The petitioner, who is the third party, is before this court. The first respondent has filed a suit against the respondent. Who are the respondents?
My lord, respondent number 1 is the.
The first respondent has filed a suit against the.
Dependent number 3.
No, the respondents 1 to 3 have filed the suit against respondent number 4, 5 and 6. Correct?
Please, ma'am.
4, 5 and 6.
Respondent number 1, 2, 3, my lord. Plaintiff number 1, plaintiff number 2, plaintiff number 3, my lord.
Seeking injunction,
Please,
seeking
and,
declaration.
respondent number 4 is the.
Injunction. In that, at the time of trial, the present IA is filed by the petitioner to implead him as a defendant. It is a case of the proposed party that there was an agreement to
Please.
purchase the suit schedule property.
Please.
And in that regard, he has paid the amount to the
50
defendant. As such, is a proper and necessary party to the suit. The court, by order impugned, had dismissed the said IA. By dismissing the IA, the court has observed that the necessary party is the one whose presence is required, and in the absence whom the suit cannot be decided completely and efficiently. The applicants have not produced any document, much less the agreement of sale. Moreover, the present suit is for declaration and injunction.
But one thing, my lord,
Admittedly, the applicants, 1 minute, admittedly, the applicants are not the owners of the suit property. That being so, if the decree is passed, their right is not affected. Apart from that, if at all they are agreed to purchase the suit property under sale agreement, their remedy is to file a suit for specific performance of the contract against the first defendant, but his participation in the present suit is not required, and dismiss the petition. Learned counsel appearing for the petitioner submits that if there is any collusion between the petitioner and the defendant, between the plaintiff and the defendant, the rights of the petitioner, third party who wants to implead himself would be affected. This aspect was not considered by the court. It is submitted that his presence in the suit proceedings is very much necessary for the effective adjudication of the dispute in the case, and also the interest of the petitioner will be protected. It is submitted that whether the petitioner, in spite of the fact that the petitioner, though the petitioner has a remedy and he will be filing a suit for specific performance, his presence in this suit is very much necessary. Anything else?
please, ma'am.
Heard the learned counsel for the petitioner, peruse the material on record. The suit is filed on 11/10/2022, seeking declaration and injunction. The petitioner, according to the petitioner herein, who is a proposed party, he has paid an amount on 5/11/2022 to the defendants
Please.
for purchasing the suit schedule property. It is a case of the plaintiff that he is the owner of the property.
Please.
And he wants a declaration in respect of the suit schedule property against the defendant. If, according to the defendant, he is entitled for any relief, or he has paid the amount to the defendant and defendant, then necessarily he has to file a suit for specific performance against the defendant. In a suit for declaration, the court will not decide about the inter se disputes between the defendant and between the contesting defendants, and also this implead party who wants to be impleaded as a defendant. It would be enlarging the scope of the suit. The court had rightly considered who is the proper and necessary party to the suit, and how if the present petitioner is not a party to the suit, what is the effect of it? In the considered opinion of this court, the court had rightly considered and rightly dismissed the petition, and this court finds no reason to interfere, accordingly dismissed.
If it is subject matter of this appeal, my lord, if it is the dependent number 3 and 4 is filed as specific performance, my lord, maybe consider within a period earlier this case is disposed.
No. For that, no liberty is required, because you are the plaintiff. Whatever you want to do, you can do.
Because, my lord, in the future, lost the property there, my lord, I think.
Yes.
Seal number 14.
Yes.
In this, I applied for the petition, my lord. I sought for a mandamus directing the respondent 1 and 2. Consider my representation necessary, your lordship.
You have given representation to whom?
To the sub-registrar, your lordship, and
To the sub-registrar.
the district registrar, your lordship.
Let's see who are the respondents.
1 and 2, lordship.
1 and 2, my lord.
1 and 2, lordship.
One and two, sub-registrar and district registrar.
Please, yes.
What is the representation?
That, your lordship, to furnish the documents, your lordship, where, your lordship, the one Maresh Rawal, who was the earlier director, has got the mortgage deal was cancelled, and also seal deed was cancelled. So, Your Lordship, I sought for a direction, made an application to the respondents to provide the documents on which basis he got the cancel the mortgage deed, Your Lordship.
That's kindly see in page number 26.
50?
In page number 26, annexure A.
Hmm.
That's the prayer of the petitioner is not maintainable for the reason that may take to third para
Reserve the-
we reserve
so-
rights to legal action
And then
including.
where is the prayer?
That Your Lordship,
Next
page
is-
number 25, Your
same.
Lordship, may kindly see.
Wherefore-
Therefore, you are called upon to provide certified copies of all documents and applications based on which cancellation mortgage deed was carried out. So what if they furnish, Your Lordship?
Record we will
Because you,
furnish.
Who are you?
that what happened, Your Lordship?
No, who are you?
That we have lent a loan, Your Lordship, to one company. One Maresh Rawal was the director. And Your Lordship, he got the said in favor of the company, Your Lordship. Subsequently, Your Lordship, the said company has availed loan from us, Your Lordship, and also mortgaged the property in our favor. Subsequently, Your Lordship, Maresh Rawal, who got cancelled the said deed and also the mortgage deed, which was executed, Your Lordship, for availing the loan in favor of the petitioners, Your Lordship, without making us as the parties.
This is.
If they provide documents, Your Lordship, on which basis, Your Lordship, I sought for direction to provide the documents. Afterwards, Your Lordship, I can avail the remedy, Your Lordship, before the court, competent court. So I sought for a mandamus, Your Lordship. If they provide the documents, I am satisfied, Your Lordship.
No, how is he duty bound to do it?
Because, Your Lordship,
There should be a source of power
yes.
from the act, from the registration act. So what is, if these kind of things, is he duty bound to do? If he is duty bound to do, we'll issue a mandamus.
Yes.
So how is he duty bound to do it?
Because what happened, Your Lordship, one Maresh was the earlier director, he resigned in the year 2017. So, and the said property, Your Lordship, which was sold in favor of the company by him, Your Lordship. And afterwards, Your Lordship, we have borrowed we have lent a loan to the company. And the said company, Your Lordship, has mortgaged the said property in favor of us. Subsequently, said Maresh Rawal has got cancelled the said deed and also the mortgage deed without making us as the parties. So, Lordship,
You should question it.
so for that reason, Your Lordship, I saw, because Your Lordship, in the proceedings, Your Lordship, I have to produce the documents. On what basis, Your Lordship, he got the cancelled the said deed.
The representation to him.
Yes, annexure, Your Lordship, page number 25, let me kindly see. That is a prayer, Your Lordship, sought in that, Your Lordship. Page number 25. Therefore, you are called upon to provide certified copies of all documents and applications based on which cancellation mortgage deed was carried out.
That we will provide, my lords. The second, other munda, subsequently, my lords. Other contents of the annexure A. In page number 26, wherefore your good self pleased to order for cancellation of the cancelled sale deed dated so and so, registered on so and so. Cancellation of
Not
the.
seeking.
Relying
Yes,
upon-
that I am not. I am not. Yes.
You are seeking a mandamus to consider a representation. If I pass an order.
I am
saying
restricting
that-
Your Lordship to provide the documents, Your Lordship.
That you should say.
Yes, yes, Your
No,
Lordship.
no, you give a representation in that regard and file a writ petition.
Yes.
No, you file these many release, cancel that, cancel this. And now if I say, so and so mandamus to consider. the
No, only Your Lordship, on
representation,
my submission, Your Lordship, may restrict my prayer and,
I can't do that.
yes,
You have
liberty
to
may be reserved.
You give a representation to the respondent.
Yes.
And you then file a memo to that effect.
Yes, Your Lordship. Next week, Your Lordship.
Yes, this is matter on 17th of February.
17.
Yes.
Seal number 15. J. Shetty.
My lord, petitioner challenging the legality and validity of the order passed by the trial court on IA number 4 under order 11 rule 14 of CPC for production of documents, my lord. My lord, the suit for partition and separate position, my lord, filed by the respondent number 1 to 4, my lord. And my lord, the respondent number 1 to 3, they have contended in their plaint that the defendants, they are enjoying the property and they are getting more than 5 lakh of
Your
income.
defendant number?
I am for a defendant number 1, my lord. And they are contending that these defendants, they are enjoying the property and they are getting more than 5 lakh income from the properties, my lord. However, I have filed application for production of the document to show that I am getting a more than 5 lakh amount from the properties, my lord. However, the trial court rejected the application filed by the defendant number 1.
Please come to the order.
Please, my lord. Order
to the
portion is
reasoning part.
page number 19, my lord.
16. Where is the order?
Page number 19, my lord. Operative portion is that.
Not operative portion. Come to the reasoning part.
Reasoning is, my lord, 18, my lord. Right.
Paragraph number 7, 6.
Yes. Reasoning is given in page number 10, my lord. As page number 18, my lord. As discussion above, the suit is for relief of partition, whereas the relationship of a plaintiff and defendants have been admitted by both the parties. Therefore, the contention of the plaintiffs to prove the suit scheduled properties are ancestral properties, and defendants have to prove that there is an oral partition, legal heirs of the late Yellava and Elas of Pirava have taken their share. Under these circumstances, it is evident that documents sought by the defendant number 1 is not necessary for adjudication of a right of both the plaintiff and defendants. Therefore, the present application filed on 17/8/2023.
Come to your affidavit.
Pardon, my lord.
IA in support of, affidavit in support of the IA.
Please, my lord. Page number 32, my lord. That second para, that the present IA be allowed and the direction be issued to the.
Read the affidavit.
That is affidavit, my lord. Affidavit of mine, my lord. Second para, my lord. The present IA be allowed and direction be issued to the other side. The other side in para number 5 of the plaint has specifically pleaded that they are
Agreed with order passed in I number 4, which is filed
Yes.
under order 11 rule 14 and 151 CPC by defendant number 1. The defendant is before this court. Then counsel appearing for the petitioner, defendant number 1 submits that when it is a case of the defendant that he is in joint possession of the property, the plaintiff, it is a case of the plaintiff that he is in joint possession of the property, and when the defendant is denying the same, and when he has filed an application under order rule or under order 11 rule 14, the court, without even considering the reason for which the said application is filed, has dismissed it, stating that the document is not necessary for adjudication of the right of both plaintiff and defendants. It is submitted that those documents are very much necessary to prove the joint position of the plaintiff, and the court ought to have allowed the said application. Considering the same, there shall be stay of all further proceedings. It shall take out hand summons on the counsel appearing to the respondent, and shall file a memo to that effect by 19th of February. All is the stay granted by this court stands vacated. And first, registry to issue notice. In addition, this. Yes,
Much
next.
Bill number 16, M. Gundwade.
Permitted to appear on behalf of the petitioner, my lords.
Yes.
Challenging the order at Annexure G,
By whom?
respondent number 4, my lord, cancelling the
Who is respondent number 4?
deputy commissioner, my lord, cancelling the registered sale deed executed here in the year 2021 under the powers conferred under section 23 of the Senior Citizens Welfare Act.
Again, sir, there is an appeal.
Deputy commissioner order, my lords.
Let's see. You that act.
Assistant commissioner, my lord, deputy commissioner, my lord. Deputy commissioner order is the final.
Senior citizens. Why it is wrong?
But he executed the gift deed is in the year 2021.
2000?
2011, my lords. Now, my lords, the respond number
11, a gift deed is executed in your favor.
in
by
favor,
the-
my lords. Initiate by my father, my lords. Then, my lords, my sister has filed a suit for partition, including these property. At the instigation of my mother, my lords, my sister, he has filed the petition before the assistant commissioner. Assistant
So,
commissioner,
When was that filed before the assistant commissioner?
it was filed before the assistant commissioner in the year 2023, my lords.
2000?
23, my lords.
What happened to that?
And wherein, my lords, the petition came to be dismissed and directed all the respondents to take care of the father, my lords.
Then against that,
That against that, my lord, see, my father preferred an petition before the appeal before the deputy commissioner. Deputy commissioner, without assigning any reasons, my lords, cancel the gift deed, the registered gift deed.
what does the gift deed say?
There is no recital, my lords, with regard to taking care and all this. Even otherwise, my lords, my father is residing with me only, my lords.
The fourth is that?
Residing with me only, my lords.
Where is the act? No, act. Should I keep it? What do you say?
Yes. I take instructions. I take instructions.
Then counsel appearing for the petitioner submits that a gift deed is executed in favor of the petitioner by the father is which respondent?
My lords, respond number 1, my lords.
By respondent number 1 father in the year 2000.
8/6/2011, my lords.
8/6/2011. When seeking cancellation of the same under the Senior Citizens Act, when he filed an application before the Assistant Commissioner, it was rejected. However, there was a direction to take care of the first respondent. Against that, the first respondent has preferred an appeal before the Deputy Commissioner. That is the fourth respondent herein. It is a grievance of the petitioner that without assigning any reasons, the order is passed by cancelling the gift deed of the year 2011. It is submitted that there is no recital in the gift deed with regard to that it is given for the purpose of taking care of the father, and in fact the father resides along with the petitioner and only at the behest of 2 and 3.
2 and 3, my lords.
2 and 3, who are the sisters?
Please, my lords.
Who are the sisters? The present application is filed, and the fourth respondent, without any assigning any reasons, has cancelled the sale deed. Considering the submission of the land council, there shall be stay of execution of the order
25/7/20.
2025 passed by the Deputy Commissioner. You take notice to whom?
4 and 5.
4 and 5.
R4 and R5.
HCG, AGA accepts notice on behalf of 4 and 5. There shall be emergent notice to 1 to 3.
Please.
List this matter immediately after service of notice. Yes,
Number 17, Nandish Patil.
For the petitioner, my lord.
Yes.
My lord, it's a fresh writ petition, my lord. My lord, the petitioner, my lord, is owner of 5 parcels of land, my lord, which he purchased in the year 2008.
What is the relief?
My lord, the relief is, my lord, now the,
Register the sale deed
Please,
pertaining to
madam.
the scheduled property.
my lord, the sub-registrar, my lord, we have approached the sub-registrar, he is duty bound to register it under the Registration Act. But my lord, it has not been completed. Your lordship may kindly see, my lord, annexure, my lord, L.
Look at the Registration Act, what it
Please.
says.
My lord, now what has happened, my lord, I purchased the land in 2008. Subsequent to which, my lord, the land came to be converted. We got necessary approval for the layout.
When did you present the document for registration?
My lord, we have presented, my lord, your lordship may kindly see annexure L, my lord. My lord, now one submission is this, my lord. In the earlier round of litigation, I had made a offline application, my lord. I had physically approached the sub-registrar. I had given a request. My lord, an endorsement was given to me stating that I have to apply online, which, my lord, in fact, I challenged before this honorable court. And this honorable court also said that I have to apply online under the Kaveri portal. Your lordship may kindly see, my lord, subsequent to that, at page 129, I have made the application online.
When?
My lord, Lord, online, the date is not forthcoming, my lord.
No, but you have to mention,
But
when you
after-
say that you have made it and they are not considering. you
I will
should-
just show that in the endorsement itself. Your lordship may kindly come to page 134, my lord. In online, my lord, when we are uploading the documents, your lordship may kindly see page 134, my lord.
Yes.
Please, my lord, your lordship may kindly see the district, taluk, hobli, village, and also the road, survey number. Everything is being entered, my lord. But at the last column, your lordship may kindly see e-sketch number. That, my lord, we are not able to upload. Because we are not able to upload that, my lord, the registration process is not being completed. My lord, this particular uploading, my lord, has to be done by them only. It is not in my hands, my lord. Already the 11 sketch is available, my lord, and time and again, my lord, I am approaching them. My lord, offline application is rejected.
Where is the written representation to them saying that because of the difficulty?
My lord,
in
they
the
are not
portal-
accepting any written application. Now, your lordship may kindly see this honorable court's order at page 120. Page 122, please. Because the process is online, they are not accepting anything which is, my lord, handwritten. Your lordship may kindly see page 122, my lord. Writ petition is partly allowed. A certiorari is issued. Annexure H and J are quashed. Petitioner is permitted to file online application accompanied by all necessary documents,
So
which
your
shall be
registration
considered by.
will be completed after how many writ petitions?
Sorry, my lord.
Your registration will be completed after how many writ petitions?
Lord, that they will have to answer, my lord, because it is their duty to upload the documents. It is their duty to complete the
My
registration.
lords,
What is happening?
my lords, it is not our duty to upload the document. He has to file an application through online by uploading all the documents. It is not my duty to, my lords, upload the documents. It is their duty to upload all the documents online through Kaveri, my lords, the software. That he has to do.
My lord,
What,
it's not
my lord,
getting completed. The last portion, my lord, when we click on it, it is blank.
My lords, he has to, please,
If something is not happening,
please.
what they are supposed to do?
They are supposed to again to resubmit their
It's
application.
again not happening.
My lords, if all the documents are submitted, the software will
There
take.
should be a redressal mechanism, is it not? The remedy is not for everybody to rush to the High
My lords,
Court.
may I make one submission, my lords. For every applications are being, my lords, received through online only. And the, my lords, if he is, my lords, providing any one of the document, he is not providing any one of the document, the online application will not be automatically, my lords, updated to them, our software also. The remedy is available for him to, if it is not accepted, again he has to apply for the online with all documents, with all scanned documents.
I'm saying, what is the next step? No,
My lords,
there should be a remedy for everything.
my lords, it is not accepted means it is not submitted. All documents are not submitted.
Something is wrong with your portal, let us assume.
My lords,
Then what do? There should be some redressal mechanism not to come to the High Court for everything.
please, my lords, what my learned friend is saying that 11 is sketch.
Get specific instructions from
Please.
your client, what is happening in this case.
Please.
And whenever there is a difficulty, for everything, is there a remedy to come to the High Court or you will do something? That you please ask your, the present writ petition is filed, seeking the following prayer. Land counsel appearing for the petitioner submits that repeatedly when he is trying to upload the
My
documents
lords,
for
one
registration.
submission, my lords, in page 133.
130?
133, last, my lords. E-sketch number he did not mention. 133,
Yes, what is that e-sketch number?
E-sketch, 11
Sketch
is
is
sketch.
available, my lord. Your lordship may kindly say, I have produced it along with my writ petition also.
It is
But the
submitted
difficulty
by
is
the
they have to upload it.
Petitioners are, whenever he is trying to upload the document for registration under the Kaveri online services.
Yes.
When it comes to the e-sketch number,
Please.
Yes.
they are not able to upload the same. As such, the registration could not be done. Then HEA submits that if the petitioner fails to upload all the documents, it will not be completed. And as per the documents that are filed before this court, the petitioner has not filed has not uploaded the e-sketch number.
Yes.
In response to that, land counsel for the petitioner
11 is sketch number.
submits that the said efforts to upload the same were futile and they were not able to do it. In fact, this e-sketch is placed before this court.
Page 112.
Placed before this court. Next para. If the respondents are accepting the documents by way of online portal, any difficulty for any applicant, there should be a mechanism in place to address their grievances. Article 226 is not the jurisdiction where the court will sit on all these issues, and these are all not the issue that has to be decided by the court. And it is the responsibility of the respondents to take appropriate measures whenever these kind of exigencies arise. The AGA shall get specific instructions, oblique objections on this by 18th of February. Yes.
Please, oblige.
And apart from this case, the respondents shall clearly state what would be the course available to any party who is not able to get through this online portal and how the objections will be dealt with.
Please.
I'm obliged.
Seal number 18. Santosh Appa Sardring.
Yes.
The Surface Act, my lords, the petitioner read it to the OTS. The respondent back, my lords, calculation is variation. This notice has to go, my lords.
Why notice has to go?
Please, Annexure C.
Of certiorari quashing the order of the magistrate under section 14, which cannot be quashed.
No, my lords, Annexure C, my lords. Loan amount statements I was produced. The amount is variation. Yes.
Amount is?
Variation, my lords.
Then what are supposed to do?
Just calculation will submit and I will settle the matter.
That you have to approach them. Why should you come to the High Court?
Many times approach, my lord, but it's not responsible.
Which is the bank?
Manipur.
Manippuram Home Finance.
Yes, my lord.
Manippuram, have they initiated any proceedings under the Surface Act?
No, it's
not. And for Manippuram Home Finance, we should give an order. Notice to the respondent.
Please.
Seal number 19.
Please.
Tesham Karvi.
Petitioner is the plaintiff before the trial court, my lords. Defendant file after the remanding the RS second appeal by this honorable court. The defendant number 1 is the file
You are the
application.
plaintiff in the suit. You are the plaintiff in the suit.
I am the plaintiff in the suit.
What is the suit for?
Suit for declaration and injunction, my lords. Here the property is regarding the vacant position, my lords. On 90, defendant number plaintiff and defendant number 2 is the brother. And other plaintiffs of plaintiff number 2 to 7 are the defendant number 2 wife and children, my lords. So the on partition, my lords, defendant 2 has got some suit property on partition 1992. Subsequently, 1993, my lord, the defendant number 2 is the brother, is executed the one GPA in favor of the plaintiff, my lords. Subsequently, he brought one loan from the KSFC for maxi cab. Subsequently, the KSFC had published an auction, my lords, because he has not repaid. Subsequently, 2012, he has repaid the entire amount. Subsequently, in 2012, my lords, the defendant number 2 brother has executed a gift deed in favor of the plaintiff number 1. So then he entered the name as per the gift deed. Then he came to know that defendant number 2 has executed a sale deed in the year 1998 on Indirabai. So Indirabai Bagli. Subsequently, Indirabai instead, my lords, she has executed one sale deed in favor of defendant number 1, who is the defendant number 1, on 2000, my lords, 6, my lords. He came to, subsequently 2013, he has filed the suit for declarations. So that was dismissed and RA is, my lord, dismissed. This court upheld and remanded the matter to the trial court. So trial court, he has filed application that during the pendence of the, my lord, appeal, he has executed, defendant number 1, executed one gift deed in favor of his son. That is, after the filing application, he came to know. He filed the application amendment.
He has already executed a gift deed in favor of somebody else.
In favor of my first plaintiff.
Sold it to somebody.
Yes, my lords. No, during that time, my lords, he has executed sale deed.
Documents or registered documents?
Yes, registered documents. In also gift deed also registered, my lord. So what happened in part, my lord?
He has executed a gift deed in your favor.
In favor of 2012, my lords.
2012.
12, my lords.
Then he has sold the property in which year?
On 1998. 1998.
So first.
1998, my lord. That is one. Second is, my lords.
1 minute. First
Please.
is the sale deed of 1998.
98, my lords.
Thereafter, there is a gift deed in your favor.
Yes, my 2012, my lords.
These two documents are registered documents.
Yes, my lords. My lords.
Then now the present gift deed in favor of the son is when?
Son, my lords. That is 24/5/2013.
25?
24/5/2023.
23.
23, my lords.
When was the RA dismissed?
RA dismissed on, my lords. There is in page number, my lords.
RA remanded.
Please remind me. That is on 6/4/23. 6/4/23, my lord. So sought for two amendments, my lords. One, they have implemented the Indirabai she is not Indira Bai. First, my lord, dependent number 2 executed first sale deed. 98. Now she was died on 2010, my lords. Before that, she has executed in favor of dependent number 1. That is on 2006. So now he is in record of rights. Dependent number 1 is the party. He is the necessary party. But so far as amendment 1 is concerned, is not necessary, my lords. They have sought in page number, my lords, amendment.
Come to the order.
Please, my lords. That is amendment application, my lords, 127, my lords.
120.
127, my lords. Annexure G.
Yes.
Under order 6 rule 17, for the reason stated accompanied so and so, dependent may kindly be permitted to amend the written statement as under. 1 para 16A, suit is bad for non-necessary parties. That is already taken, my lords. And 16B, para 4 is totally and specifically denied by the dependent. It is not true that Indira Bai had no husband and children. Deceased Indira Bai has got daughter. Unless the daughter of Indira Bai arrayed as dependent, suit cannot be decided. Daughter of deceased Indira Bai is necessary part to the suit. And B, my lord, after dismissal of the OS number so and so, plaintiff had filed IRA so and so, came to dismiss. This defendant give the suit property in the name of his son. Being an absolute owner of the suit property, dependent give the suit.
Which is not necessary.
First one is not. Indira Bai is no more, and she also executed a sale deed in favor of dependent number 1. So we have prosecuted or initiated a civil proceeding with dependent number 1. Now dependent.
Please come.
Please, my lords. The finding is given by my lord, par number 10 of the judgment, my lords, impugned order, page number 16, my lords. The running page is, my lord, par number 20.
Page number?
20, my lords.
Hmm.
Par number 10.
Yes.
By way of amendment, dependent number 1 wish to implead to facts which are material fact as
Paragraph 10.
par number 10, my lords. By way of amendment, dependent number 1 wish to implead to facts which are material fact as per dependent number 1. Counsel plaintiff state that same are not true. Whether the said facts are true or false to be considered while passing the judgment.
Please come. Agreed with the order passed in I number 10, whereby the court had allowed the application that's filed under order 6 rule 17 is allowed. The plaintiff is before this court. Then counsel for the plaintiff submits that the property, this is which scheduled property?
But should only one property. Should
Only one.
One man.
It is submitted that in the year 2012, defendant number 1 executed a gift deed in favor of the petitioner plaintiff. Gift deed or sale deed in your favor?
That is the 12, madam. Gift deed 12.
Gift deed.
2012.
Whereas he has executed a sale deed in favor of, what is her name? One,
Plaintiff number 1, my lords. Sadev, plaintiff number 1.
plaintiff number 1.
Dependent number son, name is not mentioned, my lords.
Indira Bai.
Indira Bai, that is-
Bai
Bagli.
Pagli. And she
She executed sale deed on 2006
in favor of?
in favor of dependent number 1.
In the year 2006, again, she has executed a sale deed in favor of defendant number 1. Now, the defendant number 1.
Executed gift deed
Gift deed in his.
on
in the favor of-
24/5/23.
And now, he has sought for the amendment. It is submitted by the council that when Indira Bai so-and-so has already executed a
Right.
sale deed in favor of the defendant, and defendant in turn has executed a gift deed in his favor. Now the said proposed amendment is not necessary, and without considering the same, the court had allowed the IA, considering the submission, there shall be stay of all further proceedings. See, the hand summons
Please, ma'am.
by 19th, hand summons are not filed, the stay granted by this court stands vacated.
Please, ma'am, please.
Yes, next.
Seal number 20. R.H. Changdi.
Yes.
Please, my lord, appearing for petitioner, my lord. My lord, against the petitioner are the employees of the bank cooperative society, my lord. A complaint came to be registered against the petitioner and other impleading applicants.
To quash the order dated 21/11/2025.
Please.
Passed by whom?
JRCS.
Passed by the Joint Registrar
Registrar.
Cooperative Societies.
Yes, please.
Yes. What is the order that is passed?
Please,
There
we
is
have,
no remedy against his order.
My lords, appeal remedy is there, my lords. Apart from that, my lords, the observation of the,
Remedy?
my lords, appeal is provided.
Give the act. This is filed under which section?
my lord, section 71 subclause 3.
1 minute. Seventy-one,
Subclause 3,
three.
please.
That is, the registrar or any other person to whom a dispute is referred for the decision under this section may, pending the decision of the dispute, make such interlocutory orders as he may deem necessary in the interest of justice.
Please.
This is an interlocutory order. Part.
Please.
What is the order?
Order that came to be rejected, my lord. My lord, the application was for impleading the other respondents, my lord, on whom the allegations were made. Earlier, there was a FIR registered, my lord, and parallelly, under section 69, the inquiry was initiated. Alleged offense is misappropriation, my lord. That was against 23 persons. And the inquiry was initiated only against the 11 persons, my lord.
It doesn't say so.
My lords, it doesn't say so. My lords, kindly see the objections which has been filed by the, my lords, the respondents before the, my lords, the DRC, my lords, DRCS, JRCS, in page number 61. In page number 61, my lords. Annexure C.
The order is in Kannada.
Please.
Order is passed by the JRCS, my lords. The objections filed by the, my lords, the,
File the translated copy. Okay, order. Yes, Mrs. Carter, next week. Next week, give a date, some date.
Fine.
11. Yes. Yes, 21.
Still number 21. Kumari.
I am for the petition. This is a defendant's petition, Lordship. On the ground that WS is dismissed on the ground that there is a delay of 120 days above they have filed. In 5 days, there is a delay. Page number 37 of the order, Lordship. I have filed in 5/12/2025.
What
But
do you say
as
on
per,
that?
please,
What do you say on that?
Lordship, on that
What
day,
is
it
wrong
is,
with the order?
Lordship, as per 5/12, we have filed, on the same day we have filed the WS, Lordship. It is a discretionary power of the court. With cost, it may be allowed, Lordship. Only 5 days. That they have given
Amendment brought by the rules.
rules, Lordship. It is,
Karnataka rules.
it is there, the 120, within 120 days, we have filed the WS, Lordship. But there is judgment, Lordship. With cost, we have to allow the WS.
When was, no, when did you file?
Lordship, I filed on 5/12/2025.
By that time, how many days?
4 days, Lordship. It is enough on 1/12. That is dismissed in the order, Lordship, page number 37.
20 days will complete when?
That is on 1/12/2025.
You filed on 5th.
I filed on 5/12/2025. It is the date that
Where
gives,
is the order?
Lordship, page number 37, Lordship. The trial court given the date on 5/12/2025. 25/1/2025, it is the date, Lordship. And WS, the next date is 5/12/2025. We have filed the same day, 5/12/2025, we have filed that.
That's what he has referred to the amendment.
Please.
That is 5/6/2025.
Please. It is discretionary part of the court, Lordship. It will be allowed with cost, Lordship.
Where is that amendment? Where is that amendment?
Not.
Where is the amendment? Karnataka, CPC. 40 of 2025. Won't be there in the book. This is smarter tomorrow. Yes, next.
Please.
Still number 22.
Petitioner, my lords.
MD Gunde.
My lords, present petitioner is, my lords, the plaintiff before court below. My lords, he has filed an amendment of my lord, pleadings and my lords prayer. My lords, one propositors, my lords, Abba has 2 sons. My lords, dependents are.
What is of which year?
My lords, 2007. Initially, my lords, 2004. My lord, thereafter it was transferred to Nippani court.
No,
And
when this application is filed for amendment?
my lords, this application is filed, my lords, on 3/12/2025.
So please come to your application first.
Please, my lords.
Where is it?
My lords, page number 37, my lords, annexure F,
30?
7,
Let's
seeking,
read. The affidavit, please read.
please, my lords. From para number 2, my lords, may I read? I have filed this top noted suit against the dependents for the relief of partition and separate possession. At the time of drafting the plaint, all averments required are not correctly pleaded. I have denied that will in the plaint and other requirements regarding the denial of will, but the same are not correctly mentioned in the earlier plaint. The amendment sought will clearly indicate regarding the correct and denial of the will, but the proposed amendment I have stated as where the dependents have failed to take legal action for.
I have seen. Please come to the order.
Please, my lords.
Yes. Where did you say? You simply say in the suit of 2007, certain things which I ought to have stated have not stated.
Please.
Now I will file amendment.
My lords,
Is it the
seeking
purport of
consequential
amendment?
relief, my lords, will executed by my father.
We are not on the facts.
Please,
You have all filed a suit in the year 2007.
please. 4,
Till 24. That is till 2025.
please.
You don't do anything, and now not that it is not your case that none of these facts were in your knowledge. You only say it is, I have omitted certain things which I will now clarify or amend it. Is it permissible?
My lords, in the amendment, my lords, plaint, I have sought pleadings in respect of will, my lords, I have stated. However, my lords, the
Then
prayer,
let it be. Why should you amend it now? You can't amend it. 2007 suit, 25 you say, without even any plausible explanation, that just like that you will amend the plaint.
my lords, even my lords, if delay is considered, my lords, pursue the judgment of my lords.
It all depends upon the facts of the case. And
No, my lords,
why is it?
what are the circumstances, my lords, court has to, my lords,
Tell me what are the circumstances in
my
this
lords,
case?
the judgment stated,
Forget about the judgment, your facts.
judgmentally, yeah, stated, my lords, there are, my lords, may I pass a judgment, my lords?
Not judgment. I am on facts.
Please.
On your case, what are the reasons for you not to
Lords,
seek amendment in 2007
my lords,
and to seek amendment in
my
2025?
specific case is that, my lords, my father has executed the sale deed in favor of, sale will executed in favor of his brother, the defendant's branch.
When is that?
My lords, in the year 1958,
When was the suit filed?
2004, my lords. My lords, and thereafter, my lords, within 1 month, he died after execution of my lords. My lords,
So did you say that this particular aspect was not in my notice till now, which I came to know recently? That's why I'm filing. That is not your case at all.
my lords, may take my lords to the plain averments of my lords. I have stated, my lords, but however, prayer was not sought for correction.
Give the judgment. Take it. Yes.
My lords, para number 25, my lords.
Para number?
25. 25, my lords.
Yes.
Though court is of the consider view that the following instance illustrate, para 25, my lords. Page number 14, my lords. The court of the consider view that following is insistence illustrative and not exclusively application seeking amendment of pleading can be allowed without.
You won't fall on A.
Not, my lord, seeking additional relief and H. I'm seeking H, my lords. My lords, for delay, my lords, may I take, my lords, para number 37, my lords.
Yes. Yes.
On the question of delay, the trial court also dismissed the application on the premises that the application seeking amendment was filed 10 years after the suit. Para number 38, minutes. While deciding the application seeking amendment of prayer with reference to question of limitation, the test to be applied whether the relief sought by way of amendment is barred by the time as on the date of application will answering the question.
Judgment is contrary to the several judgments of the Honorable Apex Court.
Recent judgment.
This judgment is contrary to several judgments of the Honorable Apex Court.
Though, my lords, This is also recent
If
judgment.
in this manner, if amendment of pleadings are allowed, then there is no end to the litigation. Already the civil suits are, they are pending before the courts, but you know the pendency. If in this manner, if amendments are allowed, then there is no end.
My lords, main prayer is, my lords, gone, my lords.
That no party is expected to be vigilant.
Please, please.
If he is not, courts can't come to their rescue.
My lords, I am seeking partition earlier, my lords. Now,
Whatever it is, you are the plaintiff. Suit is of the 2007, 2025, you forgot something or you are not diligent. Court shall not permit it to be done in the year 2025. First of all, pendency of a suit from 7 to 25 itself shows how the litigation is fought.
No, my lords, earlier it was transfer, my lords, it's renumbered.
Originally it is 4.
Please, please.
Now it is 7.
Please.
Which
17.
Which court is this?
My lords, earlier it was on before, my lords, Chikodi court. Later it on jurisdiction question, my lords, it was transferred to Nippani court.
Whatever reasons, I'm not inclined. If you want, I can record this order and I can pass. I can, but I'll not allow this application, the petition.
Notice, my lords.
Why notice? Already now you are happily enjoying this suit of 2004 till 2026. How long it will stay? How long it will be pending like this?
Till then,
I will direct the court to dispose of this suit within 3 months.
I mean, notice, my lords, I will.
Please come. The present petition is filed. Agreed with her. By the order passed in.
My lords, one submission. If, my lords, I seek earlier, my lords, the declaration. My lords, if not, I am seeking the will executed by my father is not viable. My lords, my entire suit till, my lords.
Can't be permitted to amend like that, Mr. Counsel. That's what I'm saying. What is the now, even for filing a written statement itself, as per the amendment, there is a timeline. Everything
Please.
under the CPC, there is a timeline. The whole purpose of it is to see at the earliest the proceedings conclude. And you can tell the reason, one reason to the court that why you have not done it. If it is in your knowledge, have you said so? No. You just say, I've said so and so. No, I'm saying it. How can it be permitted?
Lords,
That you have to understand.
the averment respect, my lords, I have stated in amendment plain.
Whatever it is, whether you are entitled, not entitled, why you are saying it now? Why you have not stated earlier? It's a simple question.
My suit
Yes.
will.
Agreed with the orders. IA number is
39.
39. If it is permitted, you will complete 100 also. Agreed with the order passed in IA number 39. For a minute, I thought I'm not rightly reading the IA number.
No, my lords, 39. Correct.
IA number 39, invoice number 129 of 2017, dated 6th January 2026. The plaintiff is before this court. Originally, the suit is filed in the year 2004, seeking partition. After transfer, the same is numbered as OS number 129 of 2017. The petitioner, the plaintiff, now files the present IA, seeking amendment of the plaint. Where is that? Just now
My
you
lords,
showed.
page number 37 and 38, my lords. IA.
It is stated that at the time of drafting the plaint, all the averments required are not correctly pleaded. He has denied the will in the plaint and the other requirements regarding the denial of the will, but the same are not correctly mentioned in the earlier plaint. The amendment sought will clearly indicate regarding the correct denial of the will. By the proposed amendment, no prejudice would be caused to the defendant, and at the same time, it is very much necessary for the effective adjudication of the dispute between the parties. The court, by order impugned, had dismissed the same. It is stated that in this case, there is sufficient material on record. There is on record pleaded by the present plaintiff in the plain paras, and there is no debate. No, not that. It is stated that the court observed that there are no proper pleadings in the plaint about the denial of will cannot be accepted by any stretch of imagination. And regarding the probating of the will is concerned, it is submitted that the present plaintiff who has filed the suit has to stand on their own legs and they cannot take benefit of any weakness in the defense. Moreover, the will is given effect and the name of Annappa was appearing as a manager of the joint family. PW2 clearly admits the arrangement accepted with the present plaintiff set up remove all that. The court has observed that in dealing with the prayer for amendment of pleadings, the court should avoid an hypothetical approach and adopt a liberal approach, but that does not bestow the applicant with an opportunity to introduce a new time-barred reliefs. As a general rule, the court shall decline amendments if a fresh suit on the new relief sought to be introduced would be barred by limitation on the date of application. It is distinguished from the fact that where the amendment merely sought to introduce an additional or a new approach without introducing a time-barred claim or cause of action, the prayer for amendment could be allowed even after expiry of limitation. In the present case on hand, it is visibly evident that the applicant has failed to act carefully with persistent attention, application, and efforts to showcase her exercise of due diligence to bring the instant application in time. The court had relied on the judgment of the apex court in Lakshmi Das Dayabai Kabarwala versus Nanabai Chunilal Kabarwala, reported in 1964, ARSC 11, and another judgment in LJ Leach and Company Limited versus Jardine Skinner and Co. Reported in AR 1957 SC 357, and also a judgment of the Jammu and Kashmir High Court in case of Alisha versus State of Jammu and Kashmir, AR 1978 Jammu and Kashmir 34. And the court came to the conclusion that when the prayer for introducing the new relief relating to declaration based on will itself is declined, the facts touching the will sought to be introduced in the body of the plaint also deserves to be rejected, and accordingly the same is dismissed. When counsel appearing for the petitioner submits that the petitioner has already made a factual basis of his pleadings. Now he is only seeking the relief. He had relied on the order passed by a coordinate bench of this court in Sri Mohammad Rafi and versus Mohammad Rafi and others versus Bande Nawaz and others, dated 16th December 2025, arising out of writ petition number 108512 of 2025. Basing on this, it is submitted that it is that the due diligence may not be looked into in all the matters, and amendment can be allowed though there is a delay, and the court had given the though not exhaustive, but the cases where it can be considered. According to the petitioner, in the petitioner will, the judgment referred to Supra comes to the rescue of the petitioner, and the court ought to have allowed the application. He submits that in the light of the said judgment, the petitioner may be permitted to amend the pleadings. Next part, having heard the land counsel for the petitioner, peruse the material on record. After amendment to the CPC, after the commencement of the trial, if the petitioner wants, if the plaintiff, if the parties wants to amend the pleadings, it has to be brought to the notice of the court that, in spite of due diligence, such a prayer could not be sought at the earliest. Now, in this writ petition, the relief that the petitioner is seeking is that the will is illegal and void, basing on the amendment, and also is seeking a prayer that to declare the will dated 18/8/1958 as bogus, illegal, void, and not enforceable under law. The suit is filed in the year 2004. Then after the transfer, it is renumbered as suit of 2017. 17.
Please.
2017. The petition, the present application is the 39th IA. The suit is pending from the last almost, not what almost, it's almost 22 years.
21.
2004 initially, we are in 26. For the last 22 years. And after 22 years, the petitioner wants to amend the prayer and also seek he wants to amend the pleadings, as well he wants to amend the prayer, and he wants a will dated 18/8/1958 is not binding on the petitioner. The judgment which the petitioner is relying on, this court is not able to consider the said judgment in the light of the law laid down by the consistent law laid down by the apex court in catena of judgments, when and how the pleadings can be amended. In this case, the petitioner is not entitled for any relief, and he cannot be permitted to amend the pleadings after 22 years, whatsoever is the reason, particularly in a case where he is seeking the amendment of the prayer of that the will is not binding on him. In that view of the matter, the writ petition is dismissed, which is devoid of merits. The trial court is directed to dispose of the suit as expeditiously as possible, but not later than 3 months, considering the fact that this is pending from the last 22 years.
Please, oblige.
23, GNR Samano.
Yes.
Petitioner participated in the tender, my lord. The forest development, my lord, the forest department has imposed the tax of 12% development charges, my lord, which is against the judgment passed by this honorable court, my lord. The issue is pending before Supreme Court, my lord. In the similar matter, my lord, the coordinate bench of this honorable court is allowed the writ petition subject to.
What did they do?
Please.
What did they do?
Imposition of FPT is questioned, my lord. The coordinate bench of this honorable court,
What is the condition that is for?
subject to result of the disposal of the CM pending before the Supreme Court and writ appeal pending before this honorable.
Under section 98A of the Act, we impose, my lords, 12% of the, my lords, the forest development charges tax under section 98A. This is amendment.
And when the writ petitions are pending and you keep on whatever the new tenders, you will impose the same condition, your SLP will be
Since,
pending.
my lords,
And what is the purpose of issuing
since the issue is pending before the Honorable Supreme Court in SLP, my lords,
either you should not call for the tenders?
Yes.
Or if you call for the tenders, because there is a stay, You shouldn't impose the very same condition.
My lords, since tender could not be stalled because, my lords, because of the pendency of the case before the Honorable Supreme Court. And my lords, it's an ongoing process. Wherever the, my lords, the need arises.
That I understand. Now
Please.
what is, no, because already there is an order.
Yes, there is an
They
order.
will again come here. So what is
My
the
lords,
purpose of calling for the
my lords,
tenders?
formally, we ask for, my lords, the payment of tax. And they came before this Honorable Court and take a order, my lords. Until, my lords, why you are, we are, my lords, once, if we didn't raise any, my lords, claim, in future, they cannot say that the authorities have not raised any claim for the, my lords, under section 98A.
While in your government is, that's what the government wants, nobody can help them. The writ petition is filed seeing the following prayer. When counsel of the petitioner submits that this is covered by a order passed by coordinate bench of this court in WP number 106806 for 2024. Learned AGA does not dispute the fact. Accordingly, the writ petition is disposed of, holding that the demand, collection and refund of FDT would be subject to the final outcome of writ appeal number 743 of 2021 and connected matters pending before this court and CA number 39742406 of 2016 and CA number 3214-3271 of 2018 pending before the Honorable Apex Court. The respondents are at liberty to take a further action only after disposal of the said matters by issuing fresh demand of tax or take action. No, this is, how can it be? How can it be covered by this? Then how this will happen? He is questioning the auction notification.
Yes.
Now, how will be benefited by this
The
order?
notification imposing, my lords, 12%.
12% only.
Forest
It
development.
is not that he is a successful bidder.
Yes, we are successful bidder, my lord. 12% cost has been imposed, my lord, in sale intimation, my lord. Then only we offered a writ petition.
Is it confirmed in your favor?
My lord, annexure B mechanism, my lord. 12% tax has been imposed, my lord.
I understand you are questioning the auction conditions.
Yes,
This order,
Yes.
how will it inure to your benefit? That I am not able to understand.
in that writ petition also we are seeking the same relief, my lord, but the date of notification and sale intimation are changes, my lord.
What are you? Please come to the facts.
My lord, the petitioner is participated in the purchasing of the forest wood, my lords. My lord, as per the sale intimation, my lord, he has successful bidder.
It is submitted the petition is surprised to see that the respondent number 3 authority has levied forest development tax to an extent on the wood purchased by the petitioner.
Yes, I have purchased the good forest wood, my lord. As per annexure A, my lord,
The tender notification called by them.
yes, my lord. As per the notification called on 7/1/2026, my lord, the sale intimation issued on 27/1/2026, my lord. After successful bidding, my lord, sale intimation has been issued by imposing 12% FDT, my lord. In that petition also 12% FDT has been imposed, my lord. We have challenged that order. The honorable, the coordinate bench of this honorable court is,
The tender notification after participating in that.
yes, ma'am.
Participating and being an highest, being the purchaser.
Yes, ma'am.
You are questioning that now.
No, my lord, they are directing us to pay the 12% FDT, my lord.
Is that, but that is not the relief you are seeking.
Annexure B mechanism, my lord.
Issue a writ of certiorari quashing the e-tender come auction notification.
Yes.
If that is quashed, what will happen?
My lord, to avoid the technical difficulty, my lord, we are seeking, but they have not imposed any condition to show that we have not imposed the forest development tax, my lord.
Writ of certiorari quashing the impute sale intimation letter.
Yes, my lord.
If that is, okay, we will quash it. What will happen?
Formally, to avoid the technical difficulty, my lord, we are seeking to quash, my lord. Last prayer is that, my lord, not to impose the 12% FDT, my lord.
In fact, he could not maintain the writ petition because he could not maintain the writ petition
But you are
because
not telling it in the
my lords,
beginning.
since my lords, many decisions have come.
No, that you were not telling in the beginning. You said it
Yes.
is covered by the judgment. How can it be?
Yes, ma'am. Once he has participated in tender notification, he could not challenge the condition also.
Only prayer is that, my lord, 12% FDT should not be imposed, my lord, as per the judgment passed by this honorable court and issue pending before the Supreme Court, my lord.
Every judgment will not apply to every case. It depends upon the facts of the case.
Right.
In those cases, those were the people who were, I don't know about this judgment. In fact, I have also passed another judgment. In that, the 12% was held to be bad, a
Right.
division bench and a Supreme Court judgment.
Yes.
They said you should not collect it pending disposal of this. How will you fall in that bracket? You will not fall,
Right.
isn't it? File your objections.
Please.
My lord, 12%, my lord, interim order may at least.
How can I grant an interim order in these facts?
My lord, in similar matter, my lord, this honorable court is disposed of the matter and granted the interim order, my lord. That is the reason, my lord, we rely on that judgment, my lord. Our lordship may kindly pass the interim.
I can't do that, what is done in the other case. No, Supreme Court judgment or the High Court judgment or in the other matters, what has been sought in that is,
Please.
people whoever have purchased it, on them, a levy was of so and so percent, which the revision bench said it is bad.
Yes.
Then it was carried to the Supreme Court. So then I also passed orders saying that you don't insist for that. So, and the same is subject to the
Result
outcome
of
of
Supreme
the,
Court. Yes.
how will you fit into this? You will not fit into this.
Prayer.
You should have shown
Well,
that
prayer
I
may be.
purchased a particular thing and as per that they have levied so and so.
Well,
That you should show.
Our lordship may mold the prayer, my lord, mold the prayer.
Shall if the pleadings and the prayer that are sought, this court is not able to understand that this is covered by a judgment in case of in WP number so and so. If the petitioner wants to file a better affidavit, a better petition, he can file an amended petition within 1 week. List this matter after a week. Yes, next.
Weeks. Seal number 24. SK. Yadav Jagdish MG.
Please, Your Honor.
Yes.
This is regard to cancellation of tender. The respondent has invited the tender on 24/6/2025 for the supply of data entry operator.
Represents City Corporation Belgavi.
Bhushan B. Kulkarni.
Yes, so and so is directed to take notice on behalf of the first respondent. Then counsel for the petition should serve the copy of the writ petition on the counsel. Registry is directed to print the name of so and so. This is matter on 10th of February. Yes.
Seal number 25.
Yes.
Please, my lord. This is petition filed by the defendant one, my lord, wherein his application is rejected by the trial court. The order 1, rule 10(2), my lord. He wanted to add the proposed defendant number 7 to 14, my lord. That came to be rejected on the ground that the defendant has no right to add the parties.
Yes.
On the ground that dominus litis law, my lord.
Dominus litis, it is
Yes,
for the
yes.
plaintiff to.
But here, my lord, the defendant also filed a written statement along with the counterclaim. He filed the counterclaim and
The order passed by the court.
yes, my lord. It's start from 42, my lord. The para number 2 is amendment, which is I stated in affidavit, my lord. That is the affidavit annexed.
Where do the court can find?
The court
that you
can
have
is
filed a counterclaim?
46, my lord.
40?
46, my
No,
lord.
counterclaim.
Counterclaim at page number 31.
31.
Yes, the 23 is my statement, my lord, and my prayer is at 31, my lord. This
The
is the
counsel appearing for the petitioner submits that when the petitioner defendant has filed an application to implead proposed defendant number 7 to 14 that came to be dismissed by the court on the ground that the plaintiff is a dominus litis and the defendant cannot file a petition to implead the parties. Then counsel submits that. In fact, the defendant has filed a written statement as well as a counter claim, and the said finding of the court is illegal, considering the same stay in this also notice, and in addition hand summons. Yes.
Hands. Seal number 26.
By 19th, the memo shall be filed or else the stay granted by this court
19.
stands vacated.
Srinivas
Yes,
P9,
next.
seal number 26.
Yes.
Srinivas 9.
The husband of the first petitioner and the son of the Lord second petitioner, he was working with the Lord second respondent. Lord, there appears some Lord misappropriation by him in the said bank. Therefore, Lord,
Register of Cooperative Societies.
yes,
Karnataka Sahakara Sangha Niyamita. Who
Lord.
has passed the order now?
Now, what has happened is, Lord, while working in the bank, Lord, he had Lord misappropriated certain amount. Therefore, inquiry under section 64 was initiated. Thereafter, Lord, the inquiry culminated into filing of the report against him. And Lord, he challenged that report under Lord section 69. That Lord section 69 such as order can only be passed against the person Lord who is defaulter. Lord, now I am the Lord family member. My property is Lord standing in mine.
You're a guarantor.
I'm not the guarantor. I'm the family member of the person who has misappropriated. My property, Lord, property standing in my name. I've been Lord subject to the Lord order of Lord surcharge under 69. Lordship, kindly see Lord page Lord annexure C,
I'll take
Huh?
instructions. I will take.
page 26.
AGA takes notice on behalf of the first respondent. The notice to the second respondent. He shall get specific instructions. List this matter on 9th.
May I seek for interim Lord?
9th. Will
Please.
pass.
Fine. Yes. Seal number 27. Girish Dharwad.
Lord, I seek leave, my lords, leave to appear through VC, my lords.
Yes.
Lord, petitioner is the defendant in a suit instituted by respondent seeking permanent injunction. My lord, petitioner is questioning the concurrent findings of the courts in granting the interim order of injunction and my lord, its confirmation by the first appellate court. Lord, my submission for my lordship's kind consideration today would be, Lord, that since there is a delay in filing this writ petition, and also for the fact that my lord, the petitioner would want to file an affidavit saying that he would not claim an equity because my lord, he is constructing a house which has already come up till my lord, the slab level. At that time, my lord, the injunction is granted. Now, the plaintiff, my lord, did not rely on any title document. Petitioner, my lord, defendant has produced a sale deed of 2021 wherein he has purchased this wood property.
Let us see the order passed in MA.
Yes, ma'am. Therefore, my lord, that would be in my humble submission for the merits. MA order, my lord, I have produced. Page number 36.
Notice to the respondent.
My request would be, my lords, my request would be this, my lord. My lords may issue emergency notice and also permit me to take out hand summons. But I'll secure his presence. A date may kindly be fixed, my lord, after 10 days.
This is matter on 16th of February.
16th.
Please,
28.
what's up?
EP party.
Yes.
Lordship, the petitioner is the sawmill, Lordship. It is established in the year 2005, Lordship. And till now it is running renewal every year by the competent authority, Lordship. All of a sudden, Lordship, respondent number 4 has
Directing respondents number 1 to 4 to release all seized equipment machinery. Who are respondent 1 to 4?
state, Lordship.
The chief conservator of forests, deputy conservator. Why
Deputy-
they have seized?
They are no authority, Lordship, because they are you are not getting the license from the concerned authority. But concerned authority is the municipality is the competent authority to issue.
Say by what? Please come to your facts. Till its machinery was seized by the fourth respondent. Yes, what do you say?
Lordship, section 163 of the Forest Act, Lordship. The amendment rules, Lordship.
Just give that.
160.
Yes.
63.
163 rules, Lordship. 1969, Karnataka Forest Rules 1969, section 163, Lordship.
Forest rules. Forest rules.
169 rule.
163, Your Lordship. Rule 163.
Yes.
Proviso 2, Your Lordship. 2A, no person shall establish a sawmill or any other sawing contrivance other than those specified in Rule 2B, 6C and 163(1) for cutting the converting timber anywhere in the state without obtaining a license from the concerned license issuing authority. The petitioner is coming under 6C, Your Lordship. Section 2, Your Lordship. Definition 6C, Your Lordship.
You have a license or you don't have a license?
Have license, Your Lordship.
Who has granted you license?
Municipal authority is the licensing authority to run the sawmill, Your Lordship.
Then why
Your
it reads otherwise? It says Deputy Conservator of
Yes,
Forest.
Lordship. Definition, please, can you come to the definition, Lordship? Section 2, Your Lordship.
Forest officer means
6C, Your Lordship. 6A is the municipal area, means the area notified under the Karnataka Municipal Acts 1964. And 6C is the sawmill and any other sawing contrivances, means a machine that is involved in shaping or sawing.
reading what 6 of what rules for the section.
Forest rules, Your Lordship. Karnataka Forest Rules 1969, Your Lordship.
You're referring to Rule 6.
6C, Your Lordship. Definition. Definition, Section 2, Your Lordship. Rule 2. 6C, Your Lordship. Sawmill and any other sawing contrivances means a machine that is involved in shaping or sawing or round timber and or re-sawing of sawn timber using machines, devices and or manufacturing of wood products, which includes sawmill, junior mill. This sawmill is coming under the 6C, Your Lordship. Forest Department is no authentic competent authority to issue license to run within the limits of
Why
city.
did you read this? 163. What is the relevancy of 163?
Your Lordship, 163 is the licensing authority. I come to the main.
Licensing authority.
Yes.
Chief Conservator of Forests.
Yes, Your Lordship. But except which coming under 6C provision.
It says
No person shall establish a sawmill or any other sawing contrivancy other than those specified in Rule 2B and 6C, Your Lordship.
it only says sub-rule 1 for cutting.
Yes, Your Lordship.
Where is sub-rule 1? Sub-rule 1 is this. No saw, pit or any other hand.
2, Your Lordship. 2A. It is amendment is carried out in the year 2013, Your Lordship.
I think there is some confusion here. If you look at 2, if you're reading 163(2),
Yes.
it says the exception is 1.
Yes, Your Lordship.
1 of what? 163(1).
Yes, sir.
Proviso 1.
Yes.
What it says? Read that 163(1).
163(1) sawing, no saw pit or any other hand sawing contrivances for cutting or converting timber shall be established within the limits of any reserved forest, protected forest, or district forest, or within 2 kilometers of such limits, or within the area specified below, without obtaining a license from the concerned. These only these 1 to 15.
163(1), these are all the of.
It is applicable to these districts only.
For others, number 2 will apply.
Yes, Your Lordship. Others, Your Lordship, no person shall establish a sawmill or any other sawing contrivances other than those specified in Rule 2B, 6C. The sawmill is coming under 6C, Your Lordship. That is my contention, Your Lordship.
What do you say?
I'll take instruction. First time it is coming, my lords.
Yes, so and so takes notice.
Kindly direct to notice
Half
to
of the
1 to
respondents.
4 state and your lordship. Respondent number 6 may be direct to take notice to Vijay.
AGA takes notice. Who takes notice for 5 and 6?
5 is Municipal Corporation.
Corporation, Koppal, who
Koppal.
appears?
Notice asked.
Notice may be issued to lordship. The sixth
Who is the
respondent
panel
Vijay Balgerimatte has appeared. In respect of respondent number 6, your lordship.
No council. क्या करते हैं पूरे म्युनिसिपैलिटीज का एक ऑल कॉर्पोरेशंस का एक ऐसा एक लिस्ट बनवाइए इसलिए ना दूसरा बनाइए यस द यू टेक नोटिस फॉर 1 to 4
Yes.
AGA takes notice for respondent 1 to 4 who are the contesting respondent
1 to 4.
and
4 is the contesting respondent, your lordship. And in respect of 6, your lordship.
AGA shall get specific instructions from the fourth respondent. It is a contention of the petitioner that his sawmill, for running his sawmill, he doesn't require a license from the forest officers.
Yes.
In fact, it is a municipal corporation who has to give him permission, and he has already obtained the permission. Yes. This is matter on 9th of February.
Please.
Yes.
Number 29, Sinande Pachapure.
Yes.
Give it respond number 2 and 3.
Yeah.
This writ petition, my lords, is by defendant number 4, my lords. Respondent number 1, my lords, plaintiff filed
What
a
is the urgency for a memo in this?
My lords, matter was set down for arguments and later, my lords, evidence has been recalled. Today it was listed, my lords, for evidence, now adjourned to 16/2, my lords.
Lord, if that is same, my lord, I will just request it on Monday or Tuesday, my lord.
Tuesday. With the request of council, the respondent. Yes, next.
Please.
30.
Seal number 30.
Please, my lordship, I am for the petitioner in this case, my lordship. Under the Surface Act, my lordship, seized by the respondent, my lordship, has seized the property, my lordship. My lordship, there is no jurisdiction DIT below 10 lakh, 20 lakh, my lordship.
Erect in the man, so and so. Order under section 14 is challenged.
Please,
On what ground?
my lordship, there is no jurisdiction by the DIT. DIT has no jurisdiction below 20 lakh, my lordship. The loan amount is, my lordship, 3 lakhs and odd, my lordship. 3 lakh and odd, my lordship. Lordship, this is the property without notice, my lordship. Order passed by the, as per order of the,
Deputy Commissioner and all are party to this.
the possession, my lordship, the land is possession, Deputy Commissioner is the Revenue Department, my lordship, in
So this is an order passed by the
senior civil.
Principal Senior Judge and CJM at Ballari.
Please.
In criminal miscellaneous number under section 14 of the Act.
Please,
Of the Surface Act.
please, my lordship.
Third
In possession is
respondent
concerned.
a Pope Finance Company.
In possession is concerned, my lordship, the Deputy Commissioner is responsible, my lordship. Therefore, I have made a party.
I should dismiss this writ petition with exemplary cause.
My lordship, kindly,
Parties who are
Worship.
unconnected with the writ petition.
my lordship, kindly permitted to delete the respondent, my lordship.
Why you don't know? Why have you added them?
Sorry,
No,
sorry,
it's not expected from advocate like this.
please,
Yes,
sorry,
list
sorry.
this matter after 2 weeks.
2 weeks.
Bless.
He's 31.
Seal number 31. Orders matters. Veena Hegde.
Steps shall be taken as per the order dated 4/9/2025 within a week from today, or else the writ petition shall stand dismissed. What was the earlier order? Order dated 4/9/2025 shall be complied with within a week from today, or else the writ petition shall stand dismissed. Yes, 32.
CS Shutter. 32.
Give the letter. A letter is addressed seeking 6 months' time for disposal of the FDP number 15 of 2012 by order dated dated 10/1/2024. 3 months time was granted. No, it's the order dated, where is the order? The letter also doesn't even contain kind of letters these are writing. When was the order? An order dated 10th January 2024 is passed, directing the court to dispose of the FDP within a period of 6 months from the date of receipt of the copy of the order. Now a letter is addressed stating that for grant another 6 months time for disposal of the FDP number 15 of 2012. Accordingly, another 6 months is granted. However, it is made clear that no further time will be granted. Yes, next.
Seal number 33.
Memo of withdrawal.
The matter has been settled before the trial court, ma'am. I seek permission to withdraw the.
The memo is filed seeking to withdraw the writ petition. It is stated that the matter has been the matter has been settled in before the trial court in the execution petition number 3 of 2024 on 10/3/2025. Hence, the petition wants to withdraw the writ petition. Memo is taken on record and dismissed as withdrawn. Yes.
Seal number 34, KL Patil.
For petitioner, Your Lordship, we have filed memo of disposal, Your Lordship.
Withdrawal.
Kindly be, withdrawal.
Withdrawal.
Kindly be withdrawn.
The memo is filed. That the petition is not interested to prosecute the matter. Accordingly, memo is taken on record and dismissed as withdrawn. And he wants to withdraw the writ petition accordingly. Yes, certified.
Seal number 35.
One submission, my lords, in this matter. Respond number 2, my name may be deleted, my lord, since Kachin Matti has appeared. My name may be deleted for.
Your
Respond number Pavan Duddatti.
so and so name to be related. Yes.
Please.
35.
Seal number 35.
I'm for respondent number 3, my lords.
Madanali. Sadiq Kanvi.
It is for defendant evidence, my lords, in trial court.
The memo, a letter is addressed with the principal district and session judge. Seeking 6 months time to dispose of OS number 118 of 2010. This court in WP number 106-223 of 2025. Date to 27/10/2025. No, not that. When was this order? No, it is by order dated 27/3/2023. Dated 27 in WP number 10026 of 2023, dated 27/2023, directed the expeditious disposal of the case within a period of 6 months. It is stated that the same could not be disposed of, hence sought for 6 months extension, same like in the earlier order. Yes, next. 636.
Seal number 36. Is it Chaklabdi?
Please, my lord. My lord, it is argued by the rejection of the 6/17 application. Now matter is settled before the trial court, my lord. The parties are intending to file the compromise petition. In the view of the interim order, they are unable to file it, my lord. I requesting the honorable court permit the parties to file the compromise petition and dispose the trial court, my lord, in respect of petition. Of filing. My lord, may I request, my lord, if at all it is not possible to file the compromise petition, again I have to report.
Can't be. Court cannot.
Therefore, I am filing the memo to permit the parties to file the compromise petition. Trial court can dispose of the matter.
And what will happen to this stay?
My lord, if it is disposed, I will withdraw it next day itself, my lord, after disposing the trial court.
Please. A memo is filed stating that the parties want to compromise the matter. Pending disposal of this petition, the court may be directed to record the compromise. Yes. Okay. The court is directed to consider the compromise petition and record the same.
Please.
Yes, are permitted to file the compromise petition. Yes, 37.
Seal number 37.
My lord, I appear. The objection is that, my lord, the agreement, my lord, of agreement between the parties, my lord, which mentions about the arbitration clause, page number 32, my lord. Page number 32, serial number 26 in the clause refers about the resolution of a dispute by appointing an arbitrator. The office has raised a now objection stating that, my lord, the place of sitting is Mumbai, hence it cannot be filed here. My lord, my humble submission is, this is the second round. Earlier, this honorable court itself has, after this objection, page number 79, my lord. This honorable court, on the basis of this, has already appointed the arbitrator. Now, the learned arbitrator has expressed his inability to continue because he has been appointed as a Lokayukt of my lord, the Maharashtra state.
No, is it correct that the seat should be at Mumbai?
Seat should be as Mumbai. The seat should be, but agreement and work were carried out in Hubli. Agreement was, my lord, has done in Hubli.
Submitted that already.
There is an order.
Very same arbitration, very same agreement. A coordinate bench of this court on 16th February 2018 has appointed an arbitrator. But again, now the office has raised objection that the seat of arbitrator is at Mumbai. Accordingly, office objection is overruled.
May I request it for notice to the respondent, my lord.
Case notice to respondent.
Obliged.
Number 38, Patil Jagdish.
Yes.
My lord, there is a direction, last date of hearing, my lord. The principal secretary has filed an affidavit which is not in consonance with the order passed by this honorable court, my lord. Admittedly, there should not be an affidavit, my lord. Now the principal secretary himself has been examining all these things, my lord. So in this case, my lord, the land of acquisition proceedings have initiated. Please.
Latest affidavit.
No, I have not filed, my lord. I have not filed, my lord. The reason why I have not filed, my lord, is the acquisition of 2011, my lord. Subsequently, there is no action has been taken. The acquisition proceedings have not been completed also. So the petitioner wanted to take a NOC from the authorities. For that, this honorable court has directed why you are not issuing these things. So affidavit of the principal secretary is not indicating when it is going to be completed and all those things.
That is all not necessary. We do not, if it is
Only
within the
submission.
realm of the
Yes, sir. My instructions are that, my lord, affidavit is this land is required because it's already part of the industrial.
We do whatever you want to do. As of now, no objection is for what? No objection is to say whether the land is acquired or not. In the true legal sense, land is not acquired.
No, they want NOC. They wanted to convert this land into the non-agriculture land. So for that purpose, they want an NOC from the authority.
For a third party's land, without acquiring it, you are bound to give that. You are bound to give that. If you want, don't, from 2011 till 26, you cannot say, we may require, we may want.
My instructions are that, my lord, we are going to issue the final notification within the.
They can't give now, without, that is lapsed long back,
No,
2011.
but under the provisions of Karnataka Industrial Area Development Board, my lord, the provisions of the the provisions of the Land Acquisition Act is not applicable. Even section 24(2) is also no application.
Let's see.
See this.
As for that, what is that you can do?
See, under the act, my lord, there is no limitation as such under the Karnataka Industrial Area Development. It's covered by decision, my lord. So which says, my lord, there is no time prescribed as like the Land Acquisition Act. So award should be passed within time band manner, and principal final notification should be passed with.
Does the act says you issue a preliminary notification for eternally, you keep it pending.
But
Property of a property
yes,
of a person.
yes, my lord, but that these propositions of law has been considered by this honorable court, my lord, which says, my lord, only which says there is no time limit is prescribed. However, this honorable court said it's within the reasonable time it has to be exercised. So that is that is the
2011 to 20.
yes, it is a inordinate delay on the part.
And I will pass a positive direction that you should give a notice, you should give a no objection certificate to them. Because how can somebody's property, you just keep it, don't pay them money,
yes,
don't acquire the property, and you say I will not give no objection.
That is really unfair, my lord.
And above all, I want the principal secretary's affidavit on file by the next date of hearing.
Yes, please. Yes, I am filing, my lord. I am filing and.
Next date of hearing, and I am going to pass another order. He has to clarify before the court.
Please.
On the last occasion, this court has passed an order dated 28/1/2026. When AAT submits that, they'll come up with the affidavit of the principal secretary. It is submitted that under the, what is this act called?
Under the Karnataka Industrial Area Development Board, KIDB.
Karnataka Industrial Area Development Act. as like in the, as like the Land Acquisition Act, there is no limitation. It is submitted that this property is required for the respondents and they would be taking appropriate steps. It is submitted that a coordinate bench of this court has held that though there is no time limit, though there is no limitation prescribed, but they have to be completed within a reasonable time. In this case, the preliminary notification is issued in the year 2011. Till 2026, nothing has happened. And at any stretch of imagination, this court is not able to understand what is the reasonable time as per the respondent. Petitioner wants an objection from the respondent because he wants to convert his land. He is the respondents either have to acquire the land and pay him the money, or they have to issue a no objection so that the petitioner will be able to deal with the land being the owner of the property. The affidavit of the principal secretary shall answer to all these queries by this court. Yes, when will you file the affidavit?
May I request it on 11th, my lord?
Yes.
Please.
11th. And no further time will be granted.
Please.
Or the court will be constrained to pass orders.
Please.
Yes. Next.
Seal number 39. Nayak, Gurunath Hemappa, AGA.
Yes, well, in this case, a false death certificate has been obtained by the respondent by giving a wrong date of death. He gets an endorsement that there is no death certificate available of Srimati Bhagirathi Bai, who actually died way back in the year 1977, my lords. The present petitioners are the legal heirs of deceased Bhagirathi Bai, who died on 29th April 1977. Now it appears.
The order is passed in a criminal miscellaneous.
We were not aware of it at all.
If you are not aware, what is the remedy against an order passed in a criminal miscellaneous? Not a writ petition.
There's no appeal provided, my lords.
If not, if there is no appeal provided, you have a criminal petition under 482, but not a writ petition. Writ petition is not at all
that
maintainable.
liberty it may be discussed.
Yes, the present writ petition is filed, seeking the following prayer. This order is passed in a criminal miscellaneous number 299 of 2017. Again, it's that order. Whatever is illegality, irregularity, the petitioner cannot come before this court. And the remedy is elsewhere. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy.
Obliged.
On submission.
Number 40.
On scene 39, my lords, I have filed wakalat for respond number one.
Respondent.
Respond number 1.
Give that.
File ಮಾಡಿದ್ದಾರೆ.
My name ಮಾಡಿದ್ದೇನೆ, but my name was not
It's
shown.
not shown. His name is not shown, my lords.
In
He
the
appears for-
earlier matter,
39, my lords.
anyhow, so and so
Disposed
submits
of.
that, he has filed wakalat,
Please,
but
ma'am.
his name is not
Not
printed. Yes. Yes, next 40. Next part.
Seal number 40.
Lordship, this Honorable Court was pleased to direct me to serve the copy of the writ petition to the counsel appearing before the family court. Lordship, he has refused to receive the copy, my lord.
Where is that?
Detailed affidavit I have filed. 3 times, my lord, I have approached, my lord, since saying that he is giving NOC and as such, he has no instruction to receive the copy. I have stated.
What is the respondents?
No, I am seeking interim order, my lord. First time, when the matter listed, directed to serve the copy, my lord. Already the lordship was pleased to quash the proceedings on the ground that once the matter is settled before the local law, unless that order is questioned, she cannot simply seek recovery of maintenance. Page number 19, my lord, annexure J.
Why the notice is ordered on that?
Notice, my lord, to serve the copy, my lord, and come back, my lord, for that reason, my lord. On that day, my lord, they didn't receive copy. For that, my lord, I have taken time. And now, my lord, they filed affidavit.
We'll see tomorrow.
Please, ma'am, in preliminary hearing, my lord.
Yes,
Okay.
this
Please.
is matter tomorrow.
Please.
Yes, next.
Seal number 41. Vidyavati M. Kottu.
Please.
My lord, I appear for petitioner.
last
Last
date of
occasion, your lordship directed the government to ascertain when they are going to pass an final order under section 19(1) and pass an award, and also, my lord, to pay the compensation. Date may be.
Yes, yes, Mr. A.
Please, my lord, as I submitted last date of hearing, my lord, this is a project, this is acquisition required for the Upper Krishna project. My lord. Only 1 minute, my lord. To the extent of more than 1 lakh acres. But the consent award is came to be consent order for the fixing of the consent award, my lord. The government has passed an order saying that it is the rate for the X land and this is the rate for the Y land. Now, my learned friend wanted to pass an consent award in pursuant to the government GO, my lord. I made a submission on last date of hearing, my lord, saying that under the section 25 of the Act, there is a time limitation. These are the cases of the lapse. The award itself has been lapsed. So therefore, in accordance with law, it has to be, the entire process has to be restarted. Now the general manager of the Upper Krishna project is present before this honorable court, madam. See, as per the instruction, madam, since the acquisition is to the extent of more than 1,30,000 acres, and the amount required is more than 75,000 crores, madam. So only I request this honorable court that authority is ready to pass a consent award. We are ready to consider the prayer of the petitioner, madam. But the only thing is that, madam, this requires some more time to pass a consent award and pay the amount, madam. My instructions are that.
When you want to acquire the property,
Please, madam.
the financial concurrence has to be there for that or not?
Madam,
Without having the money, you can't acquire the land and you say that whenever
Malad,
we feel like.
this is Upper Krishna project, Malad. No. Reason is that, Malad, till today, Malad, central government has not published the award in the official gazette, Malad. With the anticipation of that award, Malad, these are the processes have been started by the state, Malad. To give the.
When is the land acquired?
2021, my lord, their name is entered in, as per the 11.4, my lord, we cannot sell, we cannot mortgage, and we cannot create third party interest from 2021. Now we are in 2026. And in the contempt, my lord, they themselves filed an undertaking affidavit by the secretary and commissioner saying that, my lord, they will pass a general award in the month of December, my lord. They have filed a affidavit.
December 2025.
December 2025, 3/12/2025, they filed an affidavit undertaking that they will pass an general award on or before August 2026. They have not passed it, my lord. Sorry, 2023, my lord, they filed an affidavit. 2024 August, they will pass an award, my lord. They have not passed. Thereafter, learned Advocate General appeared before the court, division bench court, my lord, undertaking that they will pass a consent award if all the parties are agreed, my lord. Then all the farmers has filed an affidavit, undertaking affidavit that, my lord, they will take consent award. Now the price is fixed for dry land 30 lakhs and 40 lakhs, my lord, as per the government order, my lord. Now, these peoples are filed an petition. They will also file an undertaking affidavit saying that, my lord, they will also. Yes, my lord. Thereafter, my lord, this honorable court passed an order.
Yes, you are relying on that order. He
Yes,
says
yes,
the time
ma'am.
limit should not be fixed. That's how all this has started.
No, time frame is fixed. Already we filed an affidavit before the SLO, my lord. It is under.
In your case, in the judgment order you are relying on, a time frame is fixed.
Yes.
A positive direction is granted.
Please.
That is what he was opposing. For that only this matter is coming up.
The judgment relied by the coordinate bench, my lord, that against that we are preparing writ appeal, my lord. If my learned friend is ready for the consent award, my lord, let them file an affidavit before the authority for the consent award. It can be disposed of, my lord. It can be disposed of, my lord.
You already want to file a writ appeal. So file it against this order also. File it against this order also. Where
My only thing is that, my lord, my first legal contention is that, my lord, the court cannot pass in any order against the mandate of section 25.
then the order of this court would be the government, the respondents cannot acquire somebody's lands for 6 years. They can't keep without giving them money.
No, we are not taken the, kindly appreciate this fact, my lord. We have not taken the possession of the land, my lord. If my learned friend is ready to see all these cases, in that case also, my lord, we have taken more than 5 months time. See, we are only, I requesting to this honorable court, give the 6 months time to pass an award, my lord. And the amount will be deposited.
Time granted in the other cases.
That is last more than 1.5 years.
4 weeks time to
madam,
pass an
that
award.
acquisition contempt proceedings of itself is 2024. The last 1.5 year, because of the
Timeline you are seeking is 6 months.
6 months time to pass an award and 8 months time to deposit the amount. I am ready to file this is my statement on the instructions. On the instructions of the,
File an
madam,
affidavit.
the
Let
officer
your
is,
office file
no,
an
no,
affidavit.
officer is present before this honorable court, madam. Let me take another instructions, madam.
Dispose of the matters like this, there has to be an affidavit. It is submitted with the learned AG that within 6 months, they're going to pass an award, and within 8 months, they're going to deposit the amount. The concern, who is the? what is
Is the general manager,
General manager,
Upper
respondent
Krishna
number.
project, UKP.
He is not the authority. Actually, I have made a party as
How
finance
the-
department, my lord.
Finance,
Please wait.
I'm
is a
sorry.
general, he is not made as a party here, madam.
Which department?
Is the Upper Krishna project respondent number 4. He is coming under the 4th respondent, madam. Is the commissioner of Upper Krishna project.
General manager, Upper Krishna project, is before this court. It is submitted by the AJ that because as in the light of these submissions, the petitions may be disposed of. This court cannot pass orders basing on a submission made before this court when the implication or the consequences of that order would have a larger effect. Hence, the concern, who is the disbursing authority, who as per that.
He is the 4th respondent only, the
fourth
commissioner.
respondent shall file an affidavit before this court that within 6 months, they will pass an award. Within 8 months, they are going to
Release the
pay
amount.
the amount to the petitioner. List this matter on 16th of February. Yes, next.
16. Seal number 42.
My lord, sir. It was directed to sir on the counsel appearing for the respondents. I filed memo, my lord, sir. I have served on the counsel appearing for the respondents. My lord's respondent number
Any urgency in this?
in this urgency is that, my lord, 7th
Tomorrow it will come. I have a meeting
Please.
at 5:15. I have to
for
raise.
preliminary hearing, my lord, sir.
Yes,
Please.
next 43.
Much of.
43.
Lord, appear for a petitioner.
Yes,
Request lordship to take up entire case itself, any convenient day,
list this matter,
any convenient day,
this matter on 23rd. Yes, 44.
for final hearing.
Yes, 44.
44.
Appeal by the owner of the vehicle, my lord. Liability speaks, appeal by the owner of the vehicle. Liability speaks on the, my lord, only on the ground that, my lord,
Appeal
not
by the
produce the
owner of the
DL,
vehicle.
non-production of DL, my lord. Liability,
now?
I filed an application along with the driving license, my lord.
You have a driving license.
Yes, he had a driving license.
Filed by the owner of the vehicle. It is submitted that the liability is fixed on the owner of the vehicle on the ground that there is no driving license. Now, when application is filed under Order 41 Rule 27, producing the driving license, considering the same, there shall be stay 50%.
In fact, my lord.
50% of the amount for 8 weeks.
Please.
Yes, 45 notice to the
45?
respondents.
45
45.
notice.
For the petition, my lords.
45.
Lords, may kindly fix the date now for early hearing.
What is this?
My lords, the respondent was married the second time. The government, my lords, taking a report, places him under suspension. The suspension order is challenged before the Honorable KAT. The Honorable KAT says, my lord, that it is open for them to take action. Nevertheless, suspension order is revoked because it doesn't require the
We'll have it on 25th of February.
23rd may pray for me.
23rd, yes, 46.
23rd. Seal number 46.
Why a memo is taken of 2023 matter? I've said only the, why is this matter listed? What is urgency that is mentioned on that? Look at it. Yes, next. 46.
Seal number 46. Be convened.
Yes, this also can go. List in the month of March. Yes, 47.
47.
47.
Look at it in
Yes,
any
may
of
go.
the matters,
Yes, may
interim
go.
orders are there, please extend. Yes, 47.
47, my lord, says short point death case. My lord, hardly,
After tomorrow.
Yeah.
Yes, 48.
Seal number 48. Please, my lord. R.H. Changdi.
My lord, there was an interim order subject to deposit of 1,30,000, my lord. It was deposited, my lord. Even then, the matter.
Tomorrow.
Please.
Yes, 49.
Lords, in this matter, my lords, I made an application, my lords. There is some urgency, my lords.
I
3
see the
acres
next
of
time.
land, sugarcane crop is grown, my lords, ready for harvesting, my lords. Since from 15 days, I am not.
Please, kindly weeks time, lords. We will file the objection to the application filed.
We'll see. Yes.
There is interim order there, lord.
Wherever interim order is there, it will be extended. Yes, 50.
Seal number 50. Lingesh B. Kattemane. Lingesh Kattemane.
Beneficiary appeal, my lord. Beneficiary appeal, my lord. Neeravari.
First.
Yes, my lord.
Yes,
Same.
covered order. Yes, 51.
Seal number 51.
Yes, 51.
51, Y Lakshmikant Reddy.
Yes, next week. 52.
That's 52 appear for appellant, my lord. The insurance company appeal. There's a delay of 129 days, my lord.
Notice,
Please,
notice.
that I seek stay, my lord.
On what ground you are before the court?
My lord, the claimants, my lord, are not the dependents on the earnings of the 64-year-old.
It is submitted that the claimants are not the dependents on the deceased, who is
4 years.
64 years old, and the insurance company is before this court, 50%,
Please,
4 weeks, no permission to withdraw, notice to respond is 53.
please.
Seal number 53, MC Ukeri.
My lords, I filed an application for my lords. At the time of drafting this read petition, I have left out one person, my lords. I requesting him to,
We'll see this.
yes,
Yes, day after tomorrow.
Day after
Yes,
tomorrow.
please.
4,
54.
seal number 54, Prashant Skadevar, 54.
My lord, not to alienate the suit property, there is a.
This will come tomorrow. Yes, 55.
55,
Admit, file hearing TCR.
admit.
My lords, 55, my lords. Connected matter was dismissed. Apex court has, my lords, awarded the compensation. Only that point is, my lords has.
Tomorrow, 55.
Tomorrow,
Yes, 56.
56, Giridhar, SP.
56 also, day after, 56 day after tomorrow, 57.
Lordship, appeal by insurance company, Lordship, challenging liability, Lordship. Accident took place after the amendment of the Act, Lordship. There was a delay in filing the petition, Lordship, after 6.
The claim petition is filed after the amendment and there is a delay in filing the appeal, considering the same 50%, 4 weeks. Yes, 58.
58, seal number 58.
Appeal by insurance company, Lordship, challenging liability, Lordship. Lordship, in this case, Lordship, there is a swapping of a driver, Lordship. Swapping of a driver, Lordship. Lordship, driver whom
Submitted there on the question of liability, 50%. Yes, 59.
59 arising out of same accident, Lordship.
Yes, same, 60.
Seal number 60,
60, 61, 62, my lord, 66.
60,
Same matter.
one-
60, 61, 62, and
63,
66.
same covered matter, 63,
66 also.
66, my lord.
till 66.
No,
Yes.
1 and 2, my lord, government will not take notice.
2 and 66.
And 66. Then what about in between, is called 63,
63,
63, day after tomorrow, 64, day after tomorrow, 65,
65,
day after tomorrow, 67,
67,
Lordship, appeal by insurance company, Lordship, challenging liability, Lordship. Accident took place prior to the amendment, Lordship. Petition filed under section 164, Lordship. Same was objected, Lordship. Tribunal has granted.
stated that the accident is prior to the amendment and the application is filed under 164. But the court has granted compensation, 50%, 4 weeks. Notice, yes, 68.
Much of it.
Appeal for appellant, my lord, in 68. Appeal by the insurance company challenging quantum of compensation, my lord. The tribunal has awarded 2 lakh each towards the parent suffering, loss of amenities and.
What is the
disfigurement.
admitted amount?
Admitted amount, my lord,
Tomorrow? Yes,
20 lakhs.
69.
say tomorrow.
20 lakhs is the admitted amount.
20 lakhs is, how much is granted?
27 lakhs,
So
17,000.
20 is admitted.
20.
It is submitted that the court, the insurance company is on the quantum and the amount that is awarded is on the higher side. Considering the submission, they shall be stay on the condition that they shall deposit 20 lakhs.
Yes.
And on such deposit, the respondents are at liberty to withdraw as apportioned by the tribunal. Yes, as
Number
per the
7.
conditions imposed by the tribunal. Yes, next.
69,
My lord, it's a company appeal challenging liability on the ground that, my lord, in fact, the petitioner sustained the injuries due to fall at home as per the medical records. But the complaint is filed before the police stating that he was hit by the insured
Tribunal
vehicle.
and counts for the insurance company that there is no nexus between the injuries and the accident,
Please.
which was not considered by the court, 50%. Yes, 70.
Please.
number 70, Priti Shashank.
Insurance company appeal on liability aspect. No policy is issued by the insurance company to in respect of offending vehicle.
It is submitted that there is no existing insurance policy, say 50%. In all these matters, wherever this, no permission to withdraw. Yes, all these matters shall come on
71,
on Friday, on Thursday. Yes, if at all interim order is there, extend it. Yes.
77.
list 2,
Lord, 77. 77. Lord, last occasion, the lordship directed to that some compensation would be paid. Last occasion, but the KNN limit was directed to
This matter 77.
No,
List,
my lord.
list it on the top of the list.
As an interim measure, my lord, they have to pay compensation at least.
77, I can't hear it. I have a meeting at 77 as the top of the list tomorrow. If you want,
13th tomorrow, because I'm coming from Bangalore, 13th February.
13th February on the top of the list. Yes,
My lord, 81
13th I
cannot-
won't be sitting. 13th Friday I'll be at
16th,
Bangalore.
16th, my lord,
Huh?
16th, my lord.
Yes, 16th.
My lord, 81 also can I? My
Number
lord,
82, my lord, this is fresh
It
matter.
was me.
My lord, sir, on the last of directed to list in preliminary hearing. Again, it has been listed in A group, my lord. Tomorrow, preliminary hearing. Number 82.
82.
my lord, serial number 81 can I request from 16th or 17th February?
Tell the code officer.
Serial number
My lord.
76.
List on the.
And wherever interim order is there, interim order is extended.
Sir, list ಯಾವಾಗ?